And I beg to mention item number 20.
20?
20, 20.
20.
And the other side is here. I have taken consent after Bihu, madam.
Okay. On the request of Mr. A. Ahmed, learned counsel for the petitioner, which is made with the consent of the learned counsel for the respondents. Or Mr. Das, you were there?
Yes.
Okay. Which is made with the consent of Mr. M. K. Das, learned counsel for the respondent 2, 3, and 4, list the case on
2904.
Obliged. What the regard for item number 70 and 71?
70 and 71.
There is an IA lordship for stay vacating. That is IA number 833/2026. Some urgency in the matter lordship may come up in order stay vacating column lordship tomorrow lordship. Because inadvertently it has come in the admission because it has come for the second time, the IA. And inadvertently the order was passed in the WPC.
Tuesday. Oh, sorry, Friday.
Lordship, Friday is, I believe it is holiday lordship.
Huh? Holiday?
Maybe holiday lordship.
Maybe holiday. Then as an abandoned precaution, Monday.
Monday lordship. Much obliged.
Mr. DJ Das, learned counsel for the petitioner. No, sorry,
No,
learned
Lordship,
counsel
I'm
for the
for
applicant.
I'm for the
Applicant in IA, civil number 833/2026, and and respondent number 6 as sought for listing of the case on Monday
in order stay
in the stay vacating column. Mr. D.P. Bora,
I am for the petitioner.
learned counsel for the petition is present and has consented to the prayer.
And my lord, interim may be continued.
The list the IA along with the petitions in the stay vacating column. The interim order passed earlier shall continue till the next date of listing.
23rd March. Monday.
My lord, I beg to mention item number 18, my lord. So in this case, my lord, your lordship has directed to file the amended cost title. Amended cost title has been filed, but that is not on record, my lord. I have checked. Let the matter be taken up along with the amended cost title, my lord.
I mean, how can we take up amended cost title? It is for the registry.
Yes, ma'am. The matter may be posted, my lord. Next.
Mr. R. Islam, learned counsel for the petitioner, has submitted that he has filed the amended cost title in the meantime.
Yes.
And the same and the necessary details are to be incorporated as per the amended cost title. Necessary details are yet to be incorporated as per the amended cost title. He has thus sought listing of the case on another date. Full stop. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. List the case on so and so. The registry in the meantime shall cause necessary correction in the cost title as per the amended necessary correction as per the amended cost title.
23rd March.
May I please, your lordship, with the consent of other side, I beg to mention item number 26.
Item number
26, lordship.
Yes.
Here I have received instruction 3 weeks time.
Okay, who is for a petitioner? Mr.
A.R. Pal.
A.R. Pal, learned counsel for the petitioner, is present. Mr. B. Chaudhary, learned standing counsel.
PWD.
PWD has submitted that he has received the necessary instructions to file a counter affidavit and has sought listing of the case after
3 weeks.
She's in order to file the counter affidavit. In the meantime, the prayer is allowed, list the case on so and so.
22nd April.
Obliged.
Yes. May I please, your wish? With regard to item number 48, madam. Complied with me.
48.
Madam.
Mr. A.K. Hussain, learned counsel for the petitioner, has submitted that during the pendency of the contempt petition, the order in respect of which the contempt petition is preferred, has been complied with. In such view of the matter, the contempt petition can be closed. In view of above submission made by Mr. Hussain, the contempt petition stands closed.
May it be please your lordship, I beg to mention item number 51, lordship. Matter may be adjourned for the day only, lordship.
Okay, on the prayer of Miss
Say Khalifa on
Say
behalf. S.A. Khalifa.
Learned Counsel appearing for a petition, the case is passed over for the day. Miss
May I please?
Udas, Learned Additional Advocate General for the state respondents is present.
Lordship, I beg to mention a writ petition for listing, fresh writ petition, Lordship, for tomorrow, Lordship, kindly. Some urgency is there, Lordship.
What is the urgency?
Lordship, the person's name has been deleted from the voter list, Lordship.
No urgency now, Monday. If
Lord-
Friday is holiday, Friday. If Friday is not holiday, Monday.
So, Lordship,
Because I have seen time limit is over.
Lordship. So, Lordship, may kindly take up the matter on Tuesday, Lordship.
Monday.
Lordship, the listing of a writ petition, Friday, Lordship.
Friday, if it is not holiday, Friday.
Lordship.
May I please, your lordship? Lord, I beg to mention for listing of a fresh writ petition, Lord. Can it be on 26th of March?
Why 26? On a hearing day. 25th
My,
or 27?
my lord. Then in that case, my lord, 27. I'm obliged.
Lordship, I beg to mention item number 72, Lordship, orders. Lordship, in this matter, I was directed to file amended proceedings. That will be filed today, Lordship. I prefer this matter will be taken up to next week, Lordship.
On prayer of Mr. S. Sutradhar, Learned Counsel for the petition and leave the case on so and so, it is submitted and consent has been taken.
Obliged.
2503. Daily list for motion, item number 1.
I please your lordship. Lordship, kindly adjourn the matter for today, lordship. Children have some difficulties, lordship.
I also need time, my lord. 3 weeks time, my lord. I also.
No, we have not issued notice.
My lord, my lord, my lord.
Notice is not yet
Hi,
issued.
yes.
Because somebody said it is forest land.
My lord.
Yes, the forest has even
Ah.
inside it's a forest.
A prayer for adjournment is made on behalf of the petitioner by Miss
As suit.
S. Sud,
Yes, lordship.
Learned Counsel, post of Mr. Miss A. Udas. 1 and 7 R. Gugoi.
Question number 456.
456. Anybody APDCL, Mr. Vidas. Baki number kiti ate ase. List the case. When we want? When do we want?
After Bihu. After
After Bihu.
Oh.
Then we should notice.
Lordship, lordship.
No point. After Bihu. The petitioner. Adjournment, Miss S. Sud. The petitioner has instituted the instant writ petition seeking electricity connection to his house situated over a plot of land measuring 1 katha 5 lasses, covered by patta number 192 within bracket old synopsis of asset 764 new, at Kanchan Nagar, village number 1, Hangrabari, revenue village, Peltola Moja, Dispur Revenue Circle. Post up. The petition has canvassed that electricity connections have been provided by the respondent APDCL to all the households in that locality. Post up. Subject of the petitioner applied for a domestic electricity connection before the amended cost title. Amended would relieve. before the respondent number 3. On 16/7/2025. Complying with all the, along with all the requisite documents. As no electricity connection has been provided to the house of the petitioner situated at the subject plot. The petitioner is before this court by instituting the instant writ petition. Mr. Das, right? Mr. Das, standing as APDSL has reiterated his submission that it was decided in a meeting of the District Electricity Committee held on 6/11/2024 that APDSL authorities would require NOC from the forest officials. Posto. NOC was submitted.
No, the first, another method was work for the first circular. There was a verbal communication between the
Okay.
department, but that was not Miller. No NOC was granted.
Okay.
I am apprised of the negative.
He has submitted that electricity connection can be provided to the petitioner, subject to issuance of NOC by the forest officials. Posto. Who provided this one? Okay. Mr. Gogoi, Standing Council Forest Department, has submitted that by an office letter number so and so dated 6/1/2026. The respondent number amended cross title, amended title. 6 has informed the respondent number 3 that upon verification, it is found that the subject plot falls inside the Hangrabari Reserve Forest area. So by the letter dated 6/1/2026, comma, the respondent number 3 has been requested not to provide electricity connection on the application of the petitioner for the region that the subject plot falls inside Hangrabari Reserve Forest. So the matter would require consideration. Further consideration, issue notice returnable on so and so. Miss Udas 1, Vidas 2, 3, R. Gogoi, 1 and 7. Udas, R. Gogoi, 4, 5, 6. Extra copies, 2 working. The respondents shall file their response to bring their stance on or before the returnable date.
I'm obliged, sir. Obliged.
Item 2,
May I please, Your Lordship?
Heard Mr. K. R. Paul.
Any Majar Huya.
No, any major.
This is contempt petition, ma'am.
Contempt petition is preferred. Alleging violation, non-compliance of the direction made in an order dated 19/2/2025. Passed in a writ petition WPC number 1185/2024. Post of by the order dated 19/2/2025. The respondent number 2 was directed to examine and verify the claim of the petitioner in respect claim of the petitioner, and if after due verification, the amount claimed is found to be payable to the petitioner, then the same should be disposed of. Same should be released by following the guidelines laid down in Tamsir Ali versus State of Assam and others reported in 2008 4 GLT 1. Post of alleging that it is averred that the order dated so and so has been duly served upon the respondents herein. Issue notice, respondents, issue notice, returnable on so and so steps, speed post, working days.
4th May, 4/5. Item 3,
May I please, Lordship, can this
Bit
matter,
loud,
can this matter be passed over to time being, Your Lordship?
we don't know. So many cases.
I have the instruction, Lordship. I have the instructions, the calculation.
Everything is let's see.
Instruction as well as a payment schedule to be made by the petitioner.
How much is pending?
1,56,34,288. And the schedule is there for the payment, Your Lordship. He has paid till 5/12/2024.
And when he applied for surrender,
He applied for surrender on 1/8/2025. Before the payment of 5/9/2025.
then if a surrender application is submitted, what is the procedure?
Procedure is that he has to clear out these two cases, Your Lordship, 5/3/25 and 5/6/2025. That's the remaining balance which he has to clear. And as per his calculation, he is saying that the amount which we have quoted is completely excessive, but we have calculated and that's the amount, Your Lordship.
No, by what time this application is to be? Because once surrender means he is surrendering.
Surrendering, but there is a
The contract area.
contract area, Lordship. But
Under what rule?
Rule 16, Your Lord. Assam Maritime Concession Rule. Rule 16(1) says,
16.
yes, page 256, Your Lordship.
Surrender, yes.
It says the government may accept the request of a leaseholder or for surrender of a lease or part thereof in case where it is established that it has not been found feasible to operate a mining lease, grant for whatsoever reason, subject to condition that the lessee, number 1, has been regularly furnishing production return as required in terms of the lease agreement. Number 2, has been making the requisite step for the progressive mining closure plan as per the condition of the lease grant. Number 3, is not in default of payment of any mining dues on account of mineral concession as on the date of making such application, undertakes to pay all such dues till the expiry of the notice period, either in advance or by the way of adjustment of the security or both.
So according to you, which conditions are not fulfilled?
Is number 3, Your Lordship. Is not in default of payment of any mining dues. He has made default in payment in 5/3/2025 and 5/6/2025. So he has to make payment of these 2 cases, Your Lordship. This 2 case calculates to amount to 1 crore.
These 2.
Yes. Even
What
the
is the amount? 61 lakh.
No, the
Total is?
Total is 1 crore 56 lakhs 34,288.
So if we add this, what is it?
If we add this, that comes to 1, because if I'm Lordship present, letter is 73/2026. This 1 page which I have given, Your Lordship.
This is a table. Okay.
Yes.
Okay. Okay. So when he submitted his application on
1/8/2025.
1/8/2025.
Yes.
On that day, these 2 installments were pending. And he sought adjustment. He sought adjustment. Right. So something is pending.
Something is pending, a lot. 2 cases are still
Some
pending.
adjustment.
This either he has to. This says that
if he says okay, let us assume for a moment your calculation is correct. Right. So amount payable up to. Payable. What is in deposit? What is in deposit otherwise, according to the petitioner?
the security money he has to deposit. Security money is about 25% of the total bid value, which comes to 61 lakhs 28,690. Page 25, Your Lordship.
Page 25.
Page 25.
That can be adjusted.
That can be adjusted, but the rest remains. Now, his contention is that the amount which we are asking is excessive high, but the calculation shows it because he for till the last till 10th case he's been paying the same amount.
1/8/2025. Did he respond that after 2410 he has come to this court? After page 29.
Lordship.
After page 29, he has come straightway to the court without asking for adjustment.
No, he's not asked for any adjustment. He just simply given application for surrender.
Okay, where is Mr. P. Sharma?
Chip, he required medical attention this morning, so he was unable to medical attention this morning. So,
Yes.
Chip, N. Hazarika. N. Hazarika.
And Hazarika, learned counsel. I submitted that Mr. P. Sharma, learned counsel for the petitioner, has some main health issues needing medical attention, and has Ms. Hazarika has just sought for listing of the case on another date. Post of Mr. Gogoi Line Standing, R.R. Gogoi Line Standing Council. Forest Department has submitted that he has obtained the instruction as regards the breakup of the outstanding dues of the petitioner and a manner of calculation by which the figure has been arrived at. A figure of rupees 1,56,34,288 has been arrived at. First up, as an adjournment prayer is made, come and list the case on next week.
Next week.
25th March, 2503. Item 4.
Not present. Okay, after some time, if time permits.
Item number 5.
Item 5, item 6, item 7, item 8.
Peso.
Yes,
If Lordship has rendered a single.
but Pilot, there is a little differentiating factor. I'll just place it before my lord. The similar batch of petitions that come up, my lord is right, and my lord has passed an order.
Keeping it open to revisit.
No, but my lord, there's.
You
had
know
happened-
why this?
But what had happened here?
Last
is-
time,
Yes.
Pilot is aware of the scheme where an existing contractor or an existing transporter could enter into an agreement for sale with a bidder under the tender which is for 2015. Now, once they enter into an agreement for sale, the purchaser and seller executed certain affidavits as per the format in the tender, and certain payments such as caution money, EMD, etc. were paid. Thereafter, a window of 4 months was given from the date of LOA/LOI to complete the process of RC, transfer of RC and the PESO license. This was the scheme. In these cases, the petitioners were issued an LOA on 16/9/25, which is the similar date in the other matter. So this 4-month window was up to 15th of January 26. Now, what I have seen from this order, which my lord passed last week, is that their extensions were given to the existing contractors who were running under the earlier contract, and therefore the cars could not be made available for the testing of PESO, etc. Now, these extensions in those cases were first granted, or the only extension that was granted was till 31/10/2025. In my case, in all these petitions which are listed today, there were 2 extensions granted. The first extension was up to 31/10/2025. Thereafter, another extension, which was up to 31/12/2025. So,
In the other contract.
in the earlier contract. So, effectively, for me, the 4-month window became a 15-day window. Because till 31/12/2025, the cars were not available.
Talukdar, this court fully aware what to do with a writ petition which has emanated from a show cause notice and reply, and the final order is yet to come, and law is settled,
No,
and they are yet to take a decision. That is why this court observed that this court would be revisiting the interim order, and till the time, no substitution.
all that I am
Right.
saying, my lord.
This is a case to be decided in the motion stage itself.
I bow down to my lord. My lord,
Right.
my lord, just 2 distinguishing factors here. The first,
They are yet to take a call.
but my lord, in my case, what has happened, my lord? As I said, the window was reduced to 15 days. And number 2, my lord, here, this is not a case that I did not take steps. My lord will for a moment take page 159. They said that you complete this process by 15th of January, 9 p.m. On 15th of January, the association addressed an email. This did not reflect in the earlier order, Malad. I don't know if this email was there in the earlier matter. Malad, please have page 159. This is the association which represents all these petitioners. I beg to state, lot of TTs have been quoted under ATS in the present tender. These TTs were required to conclude the sale and other formalities within 4 months from issuance of LOA. However, we would like to state that the earlier Assam Meghalaya tender was first extended by 2 months up to 30/10/2025 BTA email dated so and so, and again by another 2 months, that is up to 31/12/2025 BTA email dated so and so. These two extensions created a lot of confusion as the TTs continued to operate till 31/12/2025. Hence, all TTs quoted under the ATS couldn't conclude the sale and complete all formalities within the stipulated time. Now, all transporters who have quoted TTs under ATS have initiated the process of completing all formalities and expected to complete the same in few days. We humbly kindly allow time to the transporters up to 31/1/2026 to complete the formalities. Now, my lords, will please have this chart. My lords, please have the chart for a moment. These are the petitioners, my lord. And if my lords looks at the column on the right side, the last 2 columns, all of them, my lords, have completed within that additional 15 days period that I sought for. But this email at page 159 was never replied to. I sought for 15 more days till 31st of January. This was not replied to. I have in the meantime complied within that window, additional window of 15 days, that is by 31st.
No, that you have sought for.
I'm sorry.
This 159 is a request from your side.
I had sought for. I'm not saying I had sought for.
But there was you do not have any right.
I don't have a right.
Just a request is made.
It's a representation, it's a request to which there was no reply. But in the meantime, because I had sought for 31st, my members have complied by 31st. And after this compliance before 31st, my lord, the 5th of March is the show cause. All that I am saying today, my lord, the show cause which contemplates immediate suspension is disproportionate. So all that I am saying, yes, let the show cause, let the hearing happen under the show cause, let those proceedings be culminated, let those proceedings be concluded. In the meantime, my lord, the suspension part be kept in abeyance. Because at the end of the day, my lords, in this batch of petitions, there are about 11 or 12 TTs which are involved. These are all 18 to 21 MTs. Well, that will disrupt the supply.
Let them take the call within a period of 10 days.
Yes, in a time frame.
Because
suspension be kept
law on the show cause notice, because you have genuine grounds.
Yes.
You have genuine grounds. And it is for them to take into consideration.
They have to decide.
They are yet to take a final call. Right?
Yes.
So it can be disposed of on the law show cause notice within 10 days.
Yes, but in the meantime, suspension be kept.
10 days, what? In a writ petition to dispose of, how can we pass an order? So, yes, we can say that no decision shall be taken to substitute the case of place under suspension. We can do that.
The only thing, my lord, in the larger interest, there will be disruption in the supply. Anyway, there is a shortage. These are 11 vehicles if they are off the road.
They are in the process. Your reply was submitted when?
My lord, on 10th and 11th, sir. In few petitions on the 10th of March and in other cases on the 11th.
My lord may come to page 147.
What will be the time period?
My lord will grant us a time period because we understand our requirements which are on the road because the work orders were issued long back in the month of my lord.
To dispose of
my lord
the show cause proceeding.
My lord.
What would be the time period you would require?
My lord, 2 weeks. 2 weeks, my lord.
Make it 10 days.
Make it.
All are same.
All are same.
All are same. One decision has to be taken and.
True, my lord.
Right.
In fact, 147, my lord. Just for a moment. 147. Page 147, my lord. This is the second extension, my lord.
No, you have to take it, all those facts.
Yes, they have consented.
Whether they were in bona fide trouble or they had.
They had the opportunity to transfer.
Yes. So all this ATS
issue. We take every aspect into account.
Every aspect. It is your convenience. Ultimately, it is your convenience.
True, my lord. True, my lord. True.
Right.
True. My lord, will not take.
May I also add this? My lord?
Okay. Mr. Talukdar, what we will propose, all this, your cases will be taken up tomorrow. Tomorrow? Yes. Morning?
Tomorrow.
Right.
My lord.
With the observation that they will take, you
I will,
prepare your authorities to
My lord,
take a decision within 10 days.
will intimate, my lord.
Right.
Will intimate that.
What are the items?
True, madam.
My lord, items 5, 6, 7,
It will be
5.
convenient for me to mark the pages
Yes.
so that we can dispose of. And facts are similar.
All facts are similar, only dates are different.
K. Talukdar for the petitioner.
Yeah, it will be here.
Any central government, union?
Central, my lord, my friend appears.
Miss
Speak on behalf of PS Financial Area Citizen.
Learned, Central Government Council, and Mr. M. Sharma, Learned Standing Council, IOC authorities are present.
2, 3, 4, 5, 6.
As list the case tomorrow. 5,
5,
6,
6, 8,
8,
10,
10,
11,
11,
14, 16.
14, 16. Anything in the supplementary?
No.
Compare 5, 6, 8, 10, 11,
14,
14, 16.
16.
14, 16. Tomorrow, 10:30.
I'm good.
Item number 7.
Mr. Talukdar, some facts I have recorded in the other order. What additional facts? Just a paragraph.
I'll put it.
Just a paragraph.
Yes. I'm ready.
Yes, madam.
Lordship, matter pertains to non-payment of payment, Lordship, and.
How old are the dues?
Lordship, page 14 is the liability statement, Lordship.
No, what is the contract order?
Lordship, it's 2020. The
Nothing.
RTI reply is recent, Lordship. It's 11.
2020. Page 14. Come to page 14.
Lordship.
These are the two.
Lordship.
Third, Miss.
Part payment already made, Lordship.
Okay. Third, Miss K.K. Chaudhary, Learned Council for the petition. Miss M. Golita,
Yes, sir.
your standing counsel?
Yes, sir.
Learned Standing Council, Public Health Engineering Department, for all the respondents. First off, the petitioner has stated that he had executed 2 number of contract works, page 14, namely construction of so-and-so pursuant to work order number so-and-so for an work order amount so-and-so. And, 232, after execution of the contract works, he submitted bills, final bills, for a total amount of rupees 18,37,165. Full stop. Subsequently, part payment to the extent of rupees 5,68,643 was made. Full stop. However, the remaining amount of rupees 12,68,522 has not yet been released to the petitioner despite his repeated approaches and representations before the respondent authorities. Post of seeking a direction to the respondent authorities to release the said amount of rupees 12 lakhs so and so. The petitioner has instituted the instant liquidation, issued notice returnable on so and so as Ms. Kolita has appeared, accepted notice on behalf of all the respondents, no formal notice, extra copies, 2 ordinance. The respondents shall bring their stand by way of an affidavit on or before the returnable date.
Date maybe.
29th April, 2904. Item 9.
Contract.
Non-payment of contractual.
Mr. D. Chakraborty, Learned Counsel for the petitioner, and D.S. Nehu.
Yeah.
Land Standing Council, Irrigation Department for the respondent number 1, 3, 4, 5, 6,
7.
and 7. Close enough. The case of the petitioner in brief is that pursuant to an work order dated 2/6/2021 for a contract work, quote unquote, synopsis also, construction of bank protection work at diversion point of Boali River, the petitioner proceeded to execute the contract work. So the petitioner stated that there was administrative approval for the contract work on 11/1/2022. The petitioner had completed the contract work on 5/12/2023. After a site verification, comma, a completion certificate was also issued. The total amount payable to the petitioner for the contract work is rupees 11,63,103. Also, as despite repeated approaches and representations, the said amount has not yet been released to the petition. The petition is before this court by the instant before this court seeking a direction to the respondent authority to release the said amount. Post of issue notice returnable on so and so as Ms. Neog. Okay, R.K. Talukdar. Standing Council Accountant General.
Lordship, in this case, Lordship, Accountant General has no role to play, Lordship, in respect of payment of his contractual.
So be there and have your payment.
My name may be deleted, Lordship. Other Lordship.
My lord, administrative approval was submitted by the irrigation department to the AG.
Lordship, AG is for Lordship, some amount is going to deduct from the government account. That is why Lordship, Accountant General is on Lordship. No role to play, Lordship, in respect of payment of the contract.
Okay. You be there, we'll dispose of on the next day. We'll make your submission. And Mr. H. Alia. Standing Council. Finance 2. Okay. Issue notice. Mr. Talvia has submitted that the respondent number 8 is not a necessary party in the instant reposting. Para last issue notice. Extra copies. The point raised by Mr. Talvia will be considered on the returnable date.
The pendency, my lord, may not, my problem.
2904. Item 12.
Lordship, similar matter, Lordship. Case 13 is the liability statement, Lordship.
Union of India. Union of India. Who is for Union of India?
A Gayan is there, Lordship.
A Gayan. Okay, now nobody is there. Page 13, I got to understand. You are Miss
PCA.
CA. For which of the respondents?
For respondent number 3 to 7.
Okay, Land Council on behalf of Mr. R.M. Das. Standing Council Water Resources Department for the respondent number 3 to 7. Page 13 or I got to next again, page 13 or 7. Part payment, no part payment. No part
No
payment.
part.
11,24,630. The learned counsel for the petition shall serve uh, 2 copies of the writ petition along with annexure to the Deputy Solicitor General of India for within 2 working days for service of notice upon the response number 1 and issue notice return.
Notice is 2904. Item third. So,
Okay, A guy only you. A guy and 1 and 2.
item 13.
May it please, Your Lordship. Here is essay issue to the re-auction process issued by issuing this re-auction notice. Initially, 13 NIT issued on 7/10. All involved some construction work at the headquarters of 2nd Assam Forest Protection Force, Jakalabanda. I participated along with 2 others. My bid was the judge to be the lowest.
Accepted.
Not accepted. Adjudged to be the lowest. And this tender inviting authority, madam, he then recommended our name in the official file. And file was sent to respondent number 2, PCCF, for necessary approval. Nothing happened for 3.5 months. Then suddenly they issued a notice communicating to the respondent number 3, not to me. Communicating the decision to cancel it and to go for fresh tender. And by which this, as a result of which this 13 retender notice was issued. Now, neither the decision of cancelling the existing tender process nor the reason for this cancellation was communicated to me, despite being L1. No public interest involved. Only reason is to accommodate one contractor of their choice.
Yes, Mr. Gogoi.
Lordship, at this stage, I'll just pray for some time to get the instruction, but as page 20 annexure A, Lordship, if it's agreed by, so there's a first appellate authority already available, Your Lordship. Page 21. There's appellate authority.
Yeah.
If it is under the statute, then you can have an appeal.
Yes.
Kindly see section 40 of the Act. It said appeal not lie in certain cases.
Public procurement.
40D. D, clause D. Cancellation of a procurement process in terms of section 26. Now, can you see 26? It says the procuring entity may, for reason to be recorded in writing, cancel the process of procurement initiated by it at any time prior to the acceptance of the successful bid. B says even after acceptance. Kindly see D, man. 26(3). The decision of the procuring entity to cancel the procurement and reason for such decision shall be immediately communicated.
Yes,
to
Mr. Gogoi, you take instruction.
The instruction, but even the Act of Rule 38 it says it has a provision for appeal, your lordship. Even the tender clause, this section, page 20, point number 7, your lordship. Annexure A, it says that bidder who seeks to appeal against any decision, action, or omission regarding this particular procurement may do so as per section 38 of the Assam Public Procurement Act.
But
2007.
a statute says cancellation of the tender process
Yes.
would not result in an appeal under section 40. That is a statute.
That's a statute law.
It cannot override.
Exactly. So I'll take the instance. A short date may be fixed.
He referred
Tender was
he
rescheduled.
has referred to section 40.
40
D.
D.
40D.
Yes.
So, what are the reasons?
I have to get in short. The reasons, your lordship.
Heart, Mr. When is the
20th, madam. To schedule on 20th. Retender.
heart, Mr. Annath, learned counsel for application? And Mr. R.R. Gogoi, learned standing counsel for his department. For all respondents. Full stop. Para. The response number 3. Published 11 number of NITs on 17/2025, inviting bids for a number of contract works mentioned therein. So the last date of submission of bids in response to the NITs dated 17/2025 was 29/10/2025. Post of. But it is the case of the petitioner that in response to the NITs command, the petitioner submitted his bids in respect of all the 11 number of construction work, contract works, along with others. After evaluation of the bids, the tender evaluation by the tender evaluation committee, the petitioner's bids for all the 11 number of contract works were adjusted L1. Post of. Accordingly, the tender inviting committee recommended the name of the petitioner for issuance of the work orders. Post of. But without any intimation to any of the participant bidders, the response number 3 has put all the 11 contract works,
All them.
on retender, provide a tender notice dated 28/2026. Post of. The last date of bid submission in response to the NITs dated 28/2026 is fixed on 20/03/2023. Post of. The petitioner, the land counsel for the petitioner, has contended that there is violation of the statutory prescription contained in section 26 of the Assam Public Procurement Act 2017. In that, a cancellation of a tender process is to be for regions recorded in writing and the decision to cancel and the reasons for such decision shall be immediately communicated to all bidders that participated in the tender process. Also, Mr. Gogoi, learned standing counsel for the department, shall obtain instruction. Shall obtain instructions as regards the decision. As regards the contentions highlighted by the learned counsel for application. Place the case on 20. 20, what is 20 or 20?
Friday,
Friday or 23?
23, Your Lordship, Monday will do.
23. 20 may be holiday.
Yes, till then, they will not finalize, work issue.
It is not going to be finalized.
But still,
If it is so hurried, then it gets suspicious.
Man.
If they do it in a hurry, we'll tackle with it.
Okay.
Obliged, Lordship.
This fixed on, 23. 23. Much.
Item 15.
The classic case of colorable exercises of power. And the facts are like this. If your lordship will kindly turn to page 23. This pertains to lifting of food grains from FCI godowns. Page 23, there is an executive instruction with regard to the subject cited above, and as per decision of the cabinet meeting held on so and so, I am directed to request you to kindly take necessary steps for accepting preferential treatment to GPSS, LMPS, WCSS in awarding of transport contracts for food grains under so and so in the respective districts if these societies are otherwise eligible as per rules. After that, madam, if your lordship will kindly turn to page 25, this was the contract awarded to me. Page 25. With reference to the subject cited above, I am to inform you that you so and so, why the so and so dated have expressed your willingness to transport the NFSA 13 rice and other allotted rice to 8 numbers of GPSs, including Messrs. South Bank so and so, under this district from December 2021 quota onwards, etc. temporarily, or I don't know what it means. In view of the above, and to avoid lapses of so and so food grains for smooth lifting and distribution, you are hereby entrusted with the transportation of food grains, both tier 1 and 2 as per government approved rates. Now, this is how I continue. There was an attempt at page 26. There was an attempt to bypass this policy decision by floating tender from the open market, and it was made open to all contractors. This was questioned. And in fact, if your lordship turns to page 28, your lordship will get the reason why this tender was floated. It was out of the blue, given to, the name itself is quite suggestive, one Dilip Bothra, who has nothing to do with GPSs, etc. Now, this was interfered with by this honorable court at page 29 it starts, and relevant portion is at page 33, para 11. There were a series of writ appeals, and orders were passed in those writ appeals. Based on that, para 11, your lordship will find the operative portion. In view of the division bench of this court in WA number so and so directing that the lifting and distribution of food grain from the designated depots should be carried out as per existing system of distribution, this court is also of the view that the NIT dated so and so cannot be acted upon till a decision is taken by the division bench of this court in the above mentioned writ appeals. So there was therefore an interim order. Now, the next. You were a party in those division cases? Yes. You were a party? Yes. Now comes there was another attempt by some parties, which your lordship will find at page 44. In fact, this is an order passed by your lordship. Somehow to oust me, page 44 it starts, and your lordship will find that your lordship was pleased to merely issue a notice in this writ petition.
Now, since they were not able to get any order in this writ petition, this impugned order gets passed. And it is virtually an attempt to overreach this honorable court's. The impugned order is at page 40. They make firstly no notice to me. Various allegations that I have failed in supplying on time, etc., etc. But the important part is this one. At page 40, the last paragraph in that page, page 40. There are various allegations. I am not troubling your lordship. Last paragraph, this is how it has got initiated. Whereas a joint prayer petition dated 13/11/25 has been submitted jointly by chairman and secretary of the so-and-so, this Sukchar is the party which tried to get an order from this honorable court, which I just pointed out. So some parties get together and lodge a complaint. And if your lordship kindly turns the page to page 41.
So these are also GPSs.
GPS.
Of the same district.
Basically.
And by that impugned order, they were also allowed.
They have been allowed and otherwise.
Are they parties? They are the beneficiary.
Not a party person, no?
Not there.
They are not there. But my lord.
I have understood your case.
Yes.
Division means this line is already there. So that is why I put the question to you.
Yes, I have.
That page 39, if you are appellant, page 39.
Yes.
If you are an appellant in this writ appeal, so you will continue to enjoy. Right? But the impugned order also is extending benefit to others. Yes. And this is this page 46 order. Yes, I have simply recorded the facts.
Yes.
Right. Nothing else, neither discarding or not allowing no privacy view. Right. Now the intended beneficiaries, those are to be parties.
That I agree, man. But just one thing I would like to point out, my lord. If your lordship will kindly come to page 42 for a minute. What the
you have a good case as on date. As on date.
Yes.
I'll say that much. But without the parties, how
the mystery? Let me point out, Lord. Just if your lordship will kindly come to page 42 for a moment. What? How the mystery?
I know I have known because at the time passing the order at page 46, I have gone through everything.
Yes.
So I know now what is going on. Right.
This perhaps my learned friend.
Yes.
I also felt since benefit is going to them.
Benefit is going to them, and they are also approaching this by making you party. You are a party there in their proceeding, is it not?
Yes.
Then it is your duty to.
Yes. That I concede, man.
This will be difficult. Make a fresh one. You have a good case as on date.
Yes, my lord.
With a writ appellate court not disposing of the appeals. You have a good case as on date.
My lord, probably, my lord, the petitioner will have to annex some more documents, my lord.
That I don't know. On that,
my lord, I am having the document, my lord. So cause because there are various anomalies, my lord. Food grains were not, my lord, lifted during the Anno Seva Din within that period, my lord.
For that, Miss
For
Das.
about 6 months, my lord.
For that, Miss Das, you have to approach the division bench.
Not in this case.
Because notice to me, madam. No notice.
Notice has been issued, my lord. So cause notice has been issued. Reply has been given.
Madam, page 39.
Page 39.
I asked the question to him. He said yes. He is a writ appellant in those writ appeals.
Correct, my lord.
Page 39.
Yeah, correct, my lord. I have seen, my lord.
Then how can, without leave from the division bench, how can you disrupt? That is why I said as on date.
My lord.
And those writ appeals for what benefit, I don't know, those are kept pending since when?
My lord.
2018.
18.
All writ appeals. All.
My lord, may I just make
Miss Das.
Correct, my lord. You are true, my lord.
No, I am not, I cannot
lord.
reach page 39, madam. I cannot overreach page 39. For that, to get it vacated, if you have insurmountable difficulties with the petitioner society in transporting
Yes,
or other societies, they should be parties there and get the order vacated because of the difficulties created by the petitioner society.
correct.
Right?
Yes, yes.
Having known everything, I did not pass any observation in the
Earlier,
order at page 46.
earlier way, yes, ma'am. Which is Malat listed
Right.
sometime, yes.
But your this is on the necessary point.
Yes, yes, that much I consider. I have to be fair.
As on that, you are a good case, since this order before the writ appeals are pending before the division bench, where you are enjoying an interim order, right? And it is not disposed of, you are having a good case. As on that, you are having a
Yes,
good
absolutely.
case.
Without
against-
vacating that, how can they?
Against the impugned order.
Yes.
But non-joinder is another.
Yes, yes, that I appreciate. So your
Mr.
lordship will give us the liberty to come back. We are.
Yes, sir, definitely. Come tomorrow also, no problem. Heard Mr. Islam will know whether Friday will be Eid holiday or
Friday, my lord, even otherwise I'm not available. Lordship, we'll make a prayer tomorrow morning.
heard Mr. I. Chaudhary and senior counsel estate by Mr. R. Islam, learned counsel for the petitioner, and Ms. Udas, learned additional senior government advocate for the state respondents. Having had the learned counsel for the parties at some length, it transpires that the petitioner needs to incorporate some more details. Mr. Chaudhary has therefore submitted that the petition may be allowed to be withdrawn with the liberty to file FS. First of the in view of the above submission made by Mr. Chaudhary, the petition stands this petition withdraw with liberty to file FS.
Obliged.
Item 17.
And it is a case of the petitioner that the company's performance bank guarantee has been withheld by the respondent without any valid justification.
Who is the respondent?
Oil India.
Oil India Limited loss.
Okay, will issue notice at this stage.
Yes.
Heard Mr.
And thus,
learned counsel for the petitioner, and Mr. A. Sharma,
For the sole respondent, Oil India Limited, standing counsel.
standing counsel.
All
All
India
India Limited for the sole respondent, full stop. Agree by retention of the performance bank guarantee in respect of a contract work which the petitioner has claimed to have executed fully.
please, is admitted for
Comma, since when?
it was for 3 years
Okay.
in 2018.
The petitioner has approached this court seeking a direction to the respondents for release of the performance bank guarantee amount of rupees US dollar 207,900. Issue notice returnable immediately after view. Whereas, as Mr. Sharma has appeared accepted notice for full respondent, no formal notice. An extra copy by tomorrow. Tomorrow?
Please, madam.
Okay. The respondent shall bring their stand by way of an affidavit on or before the returnable.
Yes, Your Lordship. 22nd April, 2204. Obliged, Your Lordship. Supplementary list, item 55.
Yes, Mr. Sharma.
Yes, Lordship. The instructions are here, if I may just place it. Pursuant to the court's order, technical committee was constituted. They have evaluated, found everyone to be disqualified. Those minutes in original are there, Lordship.
And one more contention
The
of
directions
Mr.
were to
Okay, order.
first is the compliance with the court order of cancelling the impugned order. Then comes the technical evaluation committee's constitution. And the third document is regarding the evaluation, Lordship.
Okay, sir.
Original to assembly.
You are Dulumoni Aspa.
Work was given to Dilip Kumar Bora initially.
Then Dulumoni Asqua
Filed the writ petition.
thereafter this by the judgment 1912
Yes, it was set aside.
2025 certain
And-
observations and directions.
Certain observations, more particularly that Roman 3 for a fresh evaluation also. Page 37. That fresh evaluation
So
is done.
2nd January 2026 technical evaluation
Committee
committee
was
has been constituted.
Yes, Lordship.
Then
Then
this
on
is a
6th of-
minute.
6th of February,
They set on 6th of February.
and all the bidders were evaluated.
Yes.
Fresh. And the regions are there where they have been found to be all disqualified. So,
Mr. Henrik,
so otherwise,
Mr. Sharma will facilitate copies of this to you.
Yes, Lordship.
If you have a cause of action or aggrieved, you can file a fresh
Fresh writ
petition. Instead of prolonging issue notice returnable 4 weeks, no purpose will be served.
Yes, Lordship.
Heard Mr. P.K. Henrik, learned counsel for the petition, post up. This contempt petition is before second para. As by the judgment and order dated 19/12/2025, certain directions were made, this court, on 13/3/2026, requested Mr. A. Sharma, standing counsel, Assam Plain Tribes Development Corporation Limited, APTDCL, to obtain instruction as to whether pursuant to the judgment and order dated 19/12/2025, the respondent APTDCL authorities had complied with the directions or not. Post of para. Today, Mr. Sharma, standing counsel APTDCL, has placed an order bearing number so and so, dated 24/12/2025, an order dated 2/1/2026, and the minutes of the technical minutes of proceedings of a meeting held on 6/2/2026. Full stop. Para. By order dated. By order dated 24/12/2025, the APTDCL authorities took note of the directions made in the judgment and order dated so and so supra, and cancelled the work order issued earlier.
Yes, Lordship.
To the successful bidder, post up, by the subsequent order dated 2/2/2026, the APTDCL had constituted a technical evaluation committee consisting of 8 members to evaluate the bids of all the 4 participant bidders for the contract work under reference. Post op. The technical evaluation committee is so constituted by the order dated 2/2/2026, evaluated the bids of all the 4 participant bidders, including the contempt petitioner hearing.
Yes,
in a meeting held on 6/2/2026. First off, upon evaluation of the bids, the technical evaluation committee found all the bids of all the 4 participant bidders as non-responsive. And a decision a decision has been taken to recommend for invitation of fresh tender from intending tenders. Full stop. The said decisions of the Technical Evaluation Committee are reflected in the minutes of its meeting held on 6/2/2026. Full stop. But in view of the aforesaid developments, this court, Mr. Henry, this court is of the view that there appears there is no necessity to proceed further with the contempt petition. First off, if the petitioner is agreed by any of the decisions taken by the APTDCL authorities subsequent to the judgment and order dated 19/12/2025, the petitioner is at liberty to seek appropriate remedy as permissible under the law. You
I'll
facilitate.
provide a copy.
Uh-huh.
I'll photostat and provide a copy.
Okay. And give it a copy to the court also.
Yes, Lordship. For
a set of the copies of the.
I think these are in original. I think.
Yes, I am returning it.
Yes,
The apostolated documents placed by Mr. Sharma are kept with the case record, marking it as document X. One more. Mr. Sharma has submitted that he will facilitate copies of the same. He will furnish the copies of the aforesaid orders stroke minutes to Mr. Hendik.
Immediately we'll do it now.
It will read
Oblige, Lordship.
Item 56.
Heard Mr. Sutradhar Learned Counsel for the petitioner and Upaidhya Learned Standing Counsel Irrigation Department for the response number 1 and 4. 1 to 4. Where is Nayak? Finance?
P Nayak can be recorded.
Okay, Mr. P. Nayak, Learned Standing Counsel Finance Department for the response of size full stop. The petitioner approached this court stating inter alia that he had executed 2 contract works, awarded 2 contract works, case 23. Two contract works awarded by the work order number 8 number 12. So the petitioner, after issuance of the work orders, the petitioner stated that after issuance of the work orders, he had executed one of the contract work to the extent of 100%.
100%.
And the other contract work to the extent of 60%.
He has come for the Lordship 100% only.
Huh?
Here he has prepared petition.
Only one.
Only
Okay.
Number 1, Lordship.
Seal number 1, please. Here to submitted a final bill for an amount of rupees.
It would be Lordship 1,45,00,000, 53,000 Lordship.
Oh, 36 or what? 1 crore 36 lakh 51,000 35. Post of the petitioner has also. Petitioner has drawn in support of its claim. The petitioner has drawn support to an admission of liability statement issued by the respondent number
Chief Engineer Lordship.
issued by the respondent number 2 on 18/20/02/2026. Mr. Upaidhya Learned Standing Counsel Irrigation Department has submitted that he needs some time to obtain instruction, including on the aspect of the liability, admission of liability statement issued by the respondent number 2. Issue notice returnable on so and so. As so and so, no formal notice, extra copies, 2 working days. And land standing council. Irrigation.
Lordship, I have received the
Shall ensure that its affidavit is or shall ensure to obtain an NSA instruction and to file the counter affidavit before the returnable. Take your instruction in writing.
Lordship, Lord.
Port May 4-5. Item number 57.
Yes, sir.
In this case, my lord, here, whatever, my lord, in terms of the NIT dated, my lord, 6th of February 2020.
Yes, page 19.
Yes, my lord. Now, my lord, what happened, my lord? The petitioners, my lord, whatever, they have, my lord, rejected the technical video of the petitioner, my lord.
Where is your signature in page 93?
My lord, 19 years signature is there, my down, my lord. The bottom, my lord.
What is this?
Your lordship will find at page, my lord, 93, my lord.
93. I'm
Yes, my
looking at 93.
That bottom, my lord.
Ah.
My lord, it was the 4 condition of the tender, my lord. Because the bank authority signature was there, my lord. And it was.
How do you know this is signature?
My lord.
Some
petitioner had
railway
to,
signal.
My lord, no, my lord. The
Some
petitioner
railway
had to-
signal.
While, my lord, preparing bid, my lord, technical bid, my lord.
Let us
Almost
see
500,
the
600
let us see
pages of time, my
the
lord.
let us see the bid document, sir.
The bid documents, my lord.
Let us see the bid document.
Bid documents here, my lord.
I remember 1 minute. Huh.
Moreover, my lord, bid document.
Come to page 38.
Yes, my lord. Yes, my lord.
Clause 22.
Yes, my lord. Examination of bid. Yes, there is. It is there, my lord.
Then?
My lord, signing is
How
there, my
can
lord.
the fine fall with the decision of the technical evaluation committee?
My lord, where, my lord? These are curable defect, my lord.
See,
Minor and curable defect, my lord.
Mr. Hawk, see B.
Yes, my lord. There is the.
Please see B.
Yes, my lord.
I do not declare it is a curable defect.
Properly signed, my lord. Yes, yes.
Court does not declare it is a curable.
Court does not declare. But
A B.
I have signed, my. I have
And then
every page to be signed,
expressly
but
apparent.
it was signed, my lord, but not properly signed, my lord.
What is sign?
Yeah, my lord.
What is sign?
They have.
What is sign?
Yes, there is the signature is there, my lord.
That is sign. What is the meaning of sign?
My lord, putting signature, my lord.
What is that?
That is the signature, my lord. Is other bid documents, other parts are there, my lord. Same signature. And my lord, kindly not only for the proper place, my lord, they cannot deny it, my lord. If they advise, my lord, they could have asked the petitioner to submit another one.
Where is that?
And what is the certificate, my lord? Authority to seek reference, my lord. And bank's signature was there, bank authority was there, my lord. Their signature was right there, my lord. It is not a vital part, my lord. It is not a core condition of them, my lord. And it does not violate the provision of the Procurement Act, my lord. Procurement Act also, my lord. The core condition was not violated, my lord.
Oh, when you were here with this bid document, page 31. Roman 6. F. You have to furnish this. Right. It is an essential document.
Yes, yes.
Right?
Yes, my lord.
And page 93, what you have done?
That is the.
What you have done?
My lord, that was signed, my lord, but that is not properly signed.
This is not signed.
There is a signature, my lord, down below, my lord. And my lord, one interesting thing, my lord.
See, Mr. After approaching, we had allowed you in a very fast-track manner. The particles, you got it, but you did the wrong yourself. What to do?
My lord.
And
Yes,
it
my
is
lord.
not, they have
But
followed
it is-
strictly.
my lord, it is-
What fault we can find?
Yes, my lord, it is, but it is
Or
curable.
Mr. S. Hawk, learned counsel for the
My lord, it is
petitioner.
curable, my lord. And on
That will be examined, curable, uncurable after receipt of response.
Oh.
If your signature is to be at a proper place,
Yes, yes.
right?
Yes, yes.
There is no signature, it is completely
Yes. The signature not
blank,
proper place. Yes.
right?
Yes.
And there is something like a traffic signal somewhere below, right? And properly not signed, the technical evaluation committee as per the clause, they have followed it, not responsive.
My lord.
Heard Mr. S. And it is not you alone, there are other bidders.
Yes, my lord.
Have you made them parties?
My lord,
No, my lord, I am not.
Not necessary.
my lord, have a look.
No, we do not want to proceed then. Heard Mr. They have already crossed the stage of technical bid evaluation.
My lord, may I show my lord one document, my lord? They have.
Oh, I am not foreign
But
document,
that
I am not
one-
going to see at this stage.
No,
Heard Ms. D.S. Nyog, learned standing counsel, irrigation department for all the respondents. First of para. The respondent number 2 published a notice inviting tender on 6/2/2026 for a contract work page 22. Post of last date of submission of bid was 5/3/2026. In response to the annuity, the petitioner and two others submitted their bids for the contract work. First up, the technical bids of the 3 participant bidders were opened and evaluated by the Technical Bid Evaluation Committee on 9/2026. First up, after evaluation of the bids of all the 3 participant bidders, the petitioner's bid, technical bid, has been adjudged non-responsive on the ground that in the authority to seek reference certificate was not signed by the bidder in proper place. First off, after judging the technical bid of the petitioner as non-responsive, the Technical Bid Evaluation Committee had recommended opening of the financial bids of the other 2 qualified bidders. First of all, that I agree by the decision of the Technical Bid Evaluation Committee. Agreed by the said decision. The petition is before this court. First of Ms. Neo, learned standing counsel. Department has submitted that the instant petition is non-gender of the necessary parties as 2 other bidders have been technically adjust responsive. 2 other bidders, technical bids, have already been adjust responsive and their financial bids were directed to be opened and evaluated. Furthermore, as per clause Roman 6 of subclause Roman 6 of clause 3, eligibility of bidder. The documents mentioned therein, the document named authority to seek reference from the banker of the bidder to obtain reference or seek so and so, page 31, Act 2, is an essential document as per as per clause 22. In the detailed evaluation of technical bids, the technical evaluation committee finds that the bid has not been properly signed, then they can declare the bid as it is within the discretion of the technical bid evaluation committee to adjust the bid as non-responsive. Post of the matter of the required consideration issue notice returnable on so as Ms. Nyok. No formal notice, extra copies within 2 working days. Are you pressing interim order?
Yes, my lord.
The learned counsel for the petitioner has placed for an interim relief in the form that the defect in the technical bit of the petitioner is a curable one, and the person referring to the document annexed as at page as annexed as annexer E to the writ petition. Mr. Hawk has contended that the petitioner, though the sign of the petitioner was not at the proper place, but it existed in the document. The respondents authorities, respondent irrigation department authorities could have called for a clarification from the petition in that connection, having not obtained any clarification with regard to the said document. The action of not obtaining clarification by the respondent authorities is clearly arbitrary. Clause 3 of the ITB, section 1, instruction to bidders have set forth the eligibility conditions of the bidders First of, it is mentioned, it is mentioned that the documents to criteria mentioned therein must be mandatorily uploaded through fulfilled. As per subclause Roman 6 capital F. In subclause Roman 6 F of clause 3, the document the authority to seek reference from the banker of the bidder by clauses has been made an essential document, and such a document is required to be properly signed. First of, on perusal of the on perusal of Annexer E, it is noticed that the signature of the petitioner as the bidder was not at the proper place. Though the sign, though the signature and seal of the banker can be noticed therein. First of, the mark appearing below the document is deemed to be the signature of the petitioner. First of, this court, having perused the documented Annexer E, is not persuaded to reach a view that the document was properly signed. First of, clause of the ITB provided that is the it is a TIA here from the side of it. It is a TIA who determines whether each bid is responsive or not, and if the bid is not properly signed, then the same could be a ground for non-responsiveness of the bid. Furthermore, at the stage of technical bid evaluation, two other bidders were adjust responsive. But they are not included as party respondents in the instant liquidation. First of, this court is of the considered view that the said two participant bidders are necessary parties in the instant proceeding. For the above reasons, this court is not inclined to pass any interim order to stay the tender process.
That may be made to the outcome of the writ petition, that outcome of the.
It is always outcome. You call for it.
24th April.
You have called for it. Yes.
My President. So in this case, we have obtained the instruction. Lordship, the petitioner's name was deleted from the electoral roll, Lordship, but subsequently they have approached the district election officer and they have annexed that representation in this writ petition. Considering that representation, Lordship, inquiry was conducted. Thereafter, the petitioners approached the electoral registration officer and they applied for inclusion of their name. And they already applied for the statutory remedy. And as per my instruction, their name will be included in the electoral roll before the election, Lordship.
Before that.
The-
So. So before election, it is done. Otherwise, it is not done. Appeal.
Lordship. I'm not giving the exact date, Lordship, because.
So. Shall we make the observation which was made in the earlier?
Lordship, on the similar line.
Okay. Heard Mr. A.J. Atia. Learned Counsel for the Petitioners, Mr. A.I. Ali. Learned Standing Counsel, Election Commission, India for the respondent number 2, 4, 6 and 7. Mr. S.S. Roy, Union of India.
One.
The Central Government Council for the Union of India. Respondent number 1, Union of India. Google. Who is on the State Council? S.R. Borua, Learned Senior Government Advocate Assam for the respondent number 3.
5. 3, 5 and 8.
6. 3, 5.
And 8.
In 8. In view of the nature of grievances made in this petition and the instruction placed by Mr. Ali, the petition is taken up for disposal at the motion stage itself. Post of whereof the petitioners, how many?
19.
19 in number, I have joined together to institute the present writ petition under Article 226 of the Constitution of India, stating that they have a common cause of action to espouse. Post of para. The petitioners have stated that you are members of the same family or residents of same locality?
Same locality.
Locality.
Same locality.
They are residents of the same locality. That is village Purbo Bajari Chera Kite, Chandrapur. Post office and police station Bajari Chera, district Sibhumi, within RDR, Karimganj, Assam. Post of. The petitioners have stated that for a long period of time, they have been casting their votes in both state legislative assembly elections and stroke or parliamentary elections by virtue of their enrollment, of their names as voters in the electoral rolls. They have claimed, the petitioners have claimed that all of them had casted vote in the previous elections to the state assembly, legislative assembly, stroke and or parliament as the voters from which constituency?
125 Pathakandi LC.
125. Number 125 Patharkandi
LSC.
Legislative Assembly Constituency LSC District Sribhumi, earlier Karimganj, Assam. Your ETIC numbers?
ID number.
ETIC number, please write in a page of Madam?
Yes, my lord.
Write in a page of 19.
120.
Oh, I'm not going to write.
Well, I will write, man.
Please write.
Yes, man.
And I asked you on the earlier date also.
My lord.
Mr. Atia, there are 4 of them. There are 4. There are
1, 2.
Need to change pretty book. In Nalaya. When the repetition was moved on 16/3/2026, Mr. Ali, Land Standing Council, PCI, was asked to obtain instruction whether the names of the petitioners are enrolled in the final electoral roll published for number 134. 134 Pathakandi LAC. District Sirumi.
125.
125. District Sirumi, previously Karamganj, Assam, after the special revision by today. Poster. Para. Para area 6 to Likibo. 7, 8, 10, 11. Nalai. 11 or first line to Nalaga wrong article. From the above provisions, it is there that it is within the rights of the petitioners to make an application under section 23. That's it. 10 para 12. Para 24. Para 13. Para 13. Sorry. Para 13. From the instructions placed by Mr. Ali, it can be noticed that in the instructions placed by Mr. Ali, it is mentioned that upon verification of the electoral records of the concerned polling stations under the concerned jurisdictional electoral registration officer, Patharkandi, it is found that the names of the petitioners are not present in the current electoral roll. However, a representation dated 2/3/2023
And my lord,
was submitted by the petitioners before the district commission, before the respondent number.
all the respondents.
Yes. Lordship, respond number 6.
Respond number 6. Upon receipt of the representation dated 2/6/2026 from the petitioners, the respond number 6 has immediately forwarded the representation to the respondent number
7, Lordship.
7, seeking a report in the matter. The respondent number 7 has been instructed to verify the claims of the petitioners and to take necessary action for inclusion of their names in the electoral roll, in accordance with the applicable rules, if it is found that the names of the petitioners have been deleted wrongly. From the instructions placed in the form of an office letter bearing number so dated 17/3/2026, addressed to Ali, Mr. Ali, standing counsel ECA, which Mr. Ali has said that he has permission to place it before the court, that it has been reported by the respondent number 6 that the necessary process has been initiated for inclusion of the names of the petitioners in the electoral roll. Full stop. In view of the instruction placed in the aforesaid manner, comma, the repetition is closed with a direction to the respondent number 6 and the respondent number 7 to bring the process initiated pursuant to the representation dated 2/3/2026 as expeditiously as possible, and to communicate a decision taken thereon to the petitioner forthwith thereafter. Full stop. Para. In the event the petitioners find themselves aggrieved in any manner by the decision so taken, the petitioner are at liberty to avail the statutory remedy available to them under the RP Act 1950. Full stop. The office letter dated so and so. Office letter bearing number so and so, dated 73/2026, Shukla, placed by Mr. Ali, is a future yes record, marking it as document X. Hope your teams are there.
59.
Lord, we could catch hold of Mr. J.
Yes, better. Mr. Roy, your observations.
Yes, yes, annexure J.
Annex J has
Page 263, my lord.
created havoc for the
I know, my lord.
truck owners.
Page 263, my lord.
263. You have said that these are not in your CRM DMS, Customer Relationship Management, Dealer Management System. And that has created
My lord,
situation.
actually, I received the brief. I've got limited instruction, whatever, my lord, but unless we file a proper affidavit. First of all, my lord, Vahan, that's upload, my lord, the chassis number, engine number, that has come in the year 2015, I think so.
Whatever, these are your babies.
But this OM,
all these are your babies.
yes.
You can find out their
Whatever we have received.
whether you are their parents or not.
Yes, we are parents, my lord, but we are original
Is
parents.
it only the issue?
We are original parents, my lord. But we are restricted to only the first seller, my lord, because our data is collected and uploaded with the dealers, that is consumer relationship management dealer.
Are you in a position to inspect this vehicle and
Yes.
take the chassis number and certify?
My lord, we have not physically inspected the vehicle.
Physically inspect and certify that these are our.
This is the registering authority, my lord, who has to
as per the lord tender conditions also, the registering authority is the authority in case of any doubt.
Yes.
Lordship that kindly come to two aspects, my lord.
And 1 minute, Miss Bora had also obtained instruction that day.
My lord, the other matters for this matter, my lord, you see the documents from the polygonal, they have already annexed the annexures.
Yes.
Otherwise, my lord,
a CC notice to take take instructions because the registering authority has not been made a party, the commissioner has been made a party. The registering authority of BTOs, where the holders are registered, they may not be made a party.
Commissioner of Transport, no, my lord, we are not seeking any, no, my lord, this vehicle law before, we are not seeking any relief from them, that's why, my lord. If your lordship would kindly permit me to read two documents, my lord. Please have page number 243 for a moment, my lord. Now, this is a communication by the Ministry of Road Transport and Highways to all the secretaries of the Transport Department of the state governments, including DGP, etc. Now, kindly come to paragraph 3. DigiLocker platform of the Ministry of Electronics and Information Technology, Government of India and M-Poribahan mobile app of this ministry has the facilities to pull a citizen's driving license or registration certificate or any other certificate in an electronic form. These electronic records available on DigiLocker or M-Poribahan are deemed to be legally recognized at par with the original document as per the provisions of the Information Technology Act. Now please come to para 5. In the light of the provisions of Information Technology Act 2000, it is requested to consider the documents available in electronic form in DigiLocker platform or M-Poribahan mobile app as valid under Motor Vehicles Act of 1988 and be treated at par with certificates issued by the transport authorities. Then my lord will kindly come to page number 247. This is again a communication by the Ministry of Road Transport and Highways. This is the SOP, my lord, issued on 17th of December 2018. If your lordship would kindly come to page 247, Roman 6. These electronic records available on DigiLocker or M-Poribahan are deemed to be legally recognized at par with the original document as per the provisions of the Information Technology Act. And 4.11, citizens can produce the document or other information either through DigiLocker app or M-Poribahan. So these are bound to be, these are to be treated as, even as of.
What was the document available in the DigiLocker? Say.
Yes. Now please come to page 320. 307. Today, my lord, if I access, this is what I get. This was given on 7/3/26. We got it, my lord. So kindly see, registration number is so and so, chassis number is so and so, name of the owner Hirok Jyoti Kumar, engine chassis number. This was accessed on 7/3/26. Now please come to the tender condition, my lord. Tender condition 283, my lord. Page 282. Two 2.1.3 also. On finalization of the contract, transporter shall place the truck at a location as directed by the corporation for induction. Before induction of the trucks, locations shall carry out physical verification safety checks of only those trucks bearing registration number as mentioned in LOI, provisional or final work order. When the truck is physically presented by transporter at location for induction, the authenticity of the truck is physically checked with its parameters like engine chassis number, pounced on the truck vis-a-vis that mentioned in the original document of the RC book. The aforesaid documents also should tally with the documents submitted at the time of submission of credential bid in respect of the said truck. Once the authenticity of the truck is checked with respect to physical parameters an original document and cross-verified with the document submitted in the credential bid, and if found tallied in all respect, then only the fitness of the truck for induction is checked for safety parameters. Otherwise, the truck will not be inducted. Then please come to 2.1.4. Documents which are found in order may be checked from the Road Transport Authority for verifying genuineness of the document by respective state office. Now, you yourself having said, in case of anything, please verify with the RTO. Now, RTO documents are there, my lord. Now, on the basis of this, such a harsh action has been taken.
We just show cause notice.
Yes. One second. 219, my lord. We bring to your attention that you have been awarded the work order for transportation of Indian LPG cylinder for the period from so-and-so to so-and-so for 16 number of packed trucks. It has come to our notice that you have furnished details of 14 trucks registered with your firm and offered in the above cited work order. The issue was taken with the original equipment manufacturer, that is Tata Motors, for verification of the chassis number being manufactured by them as per the RC uploaded in the tender. OEM in its reply has confirmed that barring 2 trucks bearing registration number so-and-so, none of the other chassis of the truck bearing registrations number so-and-so were manufactured by them as per their internal records. This clearly indicates you have falsified the details of the work. Well, I don't know what is the objective sought to be achieved by this, my lord. All that is required is they want a vehicle. The vehicle should be registered, vehicle should be tax paid, even otherwise, my lord. How this is going to help their cause in any way, my lord? Is it not an extraneous consideration? Apart from the fact.
Mr. Roy, since how long you are maintaining this portal?
My lord, earlier we used to, now that Parivahan, that portal is there, my lord. And we, whatever document we have assessed from this, our.
See your line 263, page 263. That is the basis for all these actions.
Yes.
Page 263. In case the chassis are very old, in that even such records may not be available in our CRM portal. These vehicles are of 2018, 19, like that.
Yes.
15 onwards.
But
15 onwards.
Lordship, we have not physically verified the vehicle or something, my lord. That otherwise our report would, I don't know what will come, but whatever we have on the basis of our portal, my lord.
Yes, Mr. Bolo.
One more thing. In the show cause notice, there is no reference to any vigilance report. In the final impugned order, Miller, they have taken note of some vigilance report.
Right. That is to be taken at the final hearing.
Yeah.
That is behind.
I think the action is too disproportionate.
That I have found. Well, how to expedite it.
Yesterday.
May it please your lordship, my lord, there are certain aspects of this case which I feel it would be unwise to intermingle. First point, my lord, the OEM, the liability and duty of the OEM is to emboss the engine and the chassis number at certain prescribed places of the vehicle as per Rule 122. So therefore, the person who embosses the chassis number or engine number originally is the OEM, and only the OEM can determine whether its embossment is genuine or it has been re-stamped over or it has been defaced in any manner, which leads to a commission inference that an offense has been committed of effacement of the original mark on the vehicle for whatever reason. So, my lord, that aspect is there. The question of, I am not even on the question of intent. Who did the effacement, who did the defacement, entered the defaced the original
There
number?
is a question of defacement of the chassis number. That is not the case.
That is not the, my lord, because I know in the report of the OEM.
We find many times, say, for not to say, in some states, the vehicles are taken from Assam, some neighboring states. Thereafter, there is to be manipulation of the chassis number and all.
Correct.
Right. This situation occurs. But it is not a case.
Well, in this case, there is a single model, Tata 1613 single model vehicle all throughout. This is the one which has been, and there is also no mention of whether it has been all these 16 vehicles have been taken for the single bidder or they have been dispersed from various original vendors.
In a context, it is not a, say, water flask or something.
Right.
Right. For keeping hot water, what is the brand?
Milton.
Milton can be duplicated. This is a huge truck. Right. And manufacturers are hardly 2 or 3. Ashok Leyland, Tata. Right. It cannot be duplicated.
Well,
These huge vehicles are not to be duplicated. That another one can say another manufacturer, XYZ Limited, can produce and manufacture such a truck.
No, that is
obviously it is Tata.
It is Tata.
Tata means Tata. Only thing is that chassis number. This chassis number and this chassis number and what? Engine number. Engine number. As per Transport Department, it tells.
As per Transport Department, as per on the RTO site.
RTO site.
Yes.
It tells. Right. Registration number, chassis number, engine number. And this report, it is neither here nor there. Page 263.
My lord, from December 2011, 80 trucks were, as per the complaint, 80 trucks of details were sent for various dealers. 5 have returned back verified till December 2011. This is on page 264. They have maintained records till at least 2011. That is what the reason why I was pointing it out. If the entire report is seen, page 263, month of manufacture, none. 264, 4 trucks are verified. One is of June 2019, one is of November 2019 at serial number 3 and 4, and below June 2022 and October 2016. And the next page, there is 1 truck of December 2011 provenance. They are maintaining records back to 2011 as per their from this report. If they are able to verify back to 2011, they are able
These petitioners have how many vehicles?
14.
Total 14. And in the other cases?
In one 16 and another 18.
So out of 80, almost how many? 16 plus 14?
16 plus 14 plus 18.
34, 52,
48.
48. Yes, Mr. Roy, you have competent officials.
Yes, my lord.
You have competent officials in Assam.
Some of them I don't know, madam, but I called up the Calcutta office, my lord. So they have limited info. But I'll check up my lord.
I can have this. Otherwise, this is going to
There is no relief.
going nowhere.
No relief has been paid against us, my lord.
Huh?
No relief has been paid against us.
No, but because of because of an act of a private party, because of the report, thus the instrumentality of the state has acted. Right. And that has entailed
huge consequence.
Huge consequence. So you are also answerable.
That will be taken up to, my lord. I take the instruction whether.
If you have a competent official, yes, we will expedite the issue.
Right.
Right.
That will be taken up to, my lord.
Sure. Because these are not Milton flasks. Yes, if there is defacement or something,
Allegations of
they can very well know. Their competent engineers can know. If it is not,
yes,
then it is already embossed. Only thing is to tally.
Well, the reason for this, as far as my knowledge goes, limited knowledge goes, is not for a duplicate manufacturer to insert its own vehicles in place of Tata, but because the year of registration is a cutoff in the tender process. Older vehicles are conveyed as newer vehicles.
I have understood your point. Okay, let them have the Instruction first.
So, my lord, the most important part is the vehicles were placed. There, people, my lord, have inspected the vehicle.
Yes.
And thereafter, had it been a case where they doubt that the embossment is, replaced or defaced or effaced, then things would have been otherwise. Now, what impelled the authority to take this view? That is something, my lord, I am finding it very difficult to understand.
Right. I am also, that is why I am making queries after queries. Everything
Yes,
comes out
Yes.
after making queries. So let Mr. Roy have this instruction.
Well, I think his assistance would be very important.
Yes, yes.
2 o'clock, my lord.
This is along with
60 and 63.
60 and 63, madam.
Item 61.
yes, sir.
Tender cancel, my lord.
Tender
I know very well your lordship's view on that day, but
No, I am not.
no,
I don't
that
have
way-
any close view.
No, your lordship doesn't have, but I got the chance to prepare myself. So that is not always a
Okay,
close view.
take me event by event, then only.
Yes, I'll just take by event.
Ah.
If your lordship can, here other side.
Oh, who is the other side?
One and four. We have served the copy to them.
Who is the other side?
PWD is there.
Huh?
PWD
PWD.
and Union of India is there.
Their names are reflected.
He's there. Yes, come. I just can start, my lord, if your lordship permits me.
Ah.
My lord, if your lordship kindly see to page 21, my lord. This is the NIT, which is floated 17th of November. This is what the work is, performance-based maintenance contract. Lordship got it, my lord. Now, please turn to page 23 is the RFP.
23.
23 is the RFP, request for proposal.
Hmm.
Right, my lord. Now, instruction at page 25.
25.
This is a notice inviting tender. Lordship got it?
Yes.
Performance-based maintenance contract. Now,
5 years.
please turn to page 29. Instruction to bidders. Now, please mark one thing, my lord, page 31. Page 31. Employer definition. Employer is at page 1.1. The employer's defined appendix to ITB invites bid for performance-based maintenance of road through e-tendering, experience so and so, so and so. Now, together, if your lordship kindly see at page 62, just for a moment, so that your lordship can connect with page 31, please see page 62, my lord. Just your lordship can note at page 62 and 31. See, employer is chief engineer. That's the reason why I have shown chief engineer PWD. Now we go back to page 31. Eligible bidder is 3, my lord, at page 31 with the eligible bidder. Now please mark, my lord, at page 32, qualification of bidder. Now, qualification of bidder is 4.1. Now, if you turn to next page, 33, F, scan copy, all these are required. Scan copy of reports, financial standing of bidder, and a certificate from CA as a proof of turnover for last 5 years. Now, if you see, now back to 2, after 33, 2, such other certificate defined in section 3. Section 3 is 67. This is 67. Is section 3.
67.
67. Section 3.
Yes.
Now, this section 3, if your lordship looks into it, page 68 is the details of bidder. Now, 69. Now, please turn again to page 74, annexure appendix 1A with financial capacity of the bidder. Because what I am shown 33F, page 33 is this is what you have to do it. Financial capacity of the bidder. Now, what is required at page 75? Reflect A.
at page 75 reflect the financial situation of the bidder, be audited by statutory auditor. And this CD is required. Now, my lord will please turn to page 42 now. There are two bid system. One is technical bid. Your lordship will find at 42, preparation of bid 12, documents comprising of bid two parts, lordship got it, two parts, 12.1. The e-bid submitted shall be in two parts, part 1 and part 2. Part 1 shall be named technical bid and shall comprise of information submitted. Section 3. So I took to your lordship the section 3 as well as form given in section 4 of the bid document. Now 12.2 original document. Now these are what is required. Now please turn to page now at page 50, my lord. All the certificates, registration, which will be submitted at page 50, validity of registration. In respect of RFP, registration should be valid at the time of submission of bid and at the time of acceptance of bid. If the bidder was validly registered at the time of acceptance, registration shall not be a relevant consideration during contract execution.
So registration means registration.
All the registration, suppose I have got a labor license registered, so that has to be valid at the time of submission of it. Now, this clause is important, page 53, my lord. How to evaluate bid opening, clarification, bid and bid evaluation. Now, suppose technical bid is open, there is a BEC, bid evaluation committee, my lord. Now, this is bid of opening, clarification of bid and evaluation. 23.1, bid opening shall be carried in two-stage technical bid, open on a date so and so, whose technical bid so and so, financial bid, other technical has to determine to be substantially responsible, shall be open on a subsequent date through online process, e-tendering, which will be notified to such bidder. Now, 23.3, employer will prepare minutes of bid opening, including the information disclosed to those present in accordance with clause 23. I will show the minutes how they have prepared minutes. Now, 23.4. The bid accompanied with bid security bid document field will be taken up by so and so and other info furnished in so and so. As soon as possible, employer will finalize the list of responsive bidders whose financial bids are eligible for consideration. However, to assist in the examination evaluation of technical bid, employer may at his discretion ask any bidder for clarification of bid. However, please mark, my lord, no additional document in support of clarification shall be entertained. So there is a provision where they can sought for clarification from along the bidders. But there is no question of additional document to be supplied. Now, 23.5, this is important. Employer shall inform the bidders about the result of technical evaluation by uploading on the web portal, giving 7 days time for objection, if any, from the bidders. The employer shall finalize the evaluation of technical bid after due consideration of objection received, intimate the bidders whose technical bids are found responsive on that day, time and place of opening of financial bid. Bidders who inform or their representative may attend the event or opening of financial bid. This is one part. Now see 23.6. One, it is declared as responsive, my lord. At the time of opening of the financial bid, names of the bidders whose bids were found responsive in accordance with clause 23.5 will be announced. The financial bids of only these bidders will be open. Responsive bidders name, the bid price, the total amount of each pursuant to so and so. Detail may consider appropriate will be announced by employer at the time of bid opening. Now, my lord, 23.7. Employer shall prepare the minutes of opening of the financial bid. Now, there are two parts. One is technical, one is financial. Now, at page 54, 26.1. During the detailed evaluation of technical bid, the employer will determine whether each bids A meets the eligibility criteria defined in clause 3 and 4, which I have shown, my lord, clause 3, my lord, and 4, contain the required document as per format given in RFP and documents uploaded, is substantial responsive to requirement of bidding document, D is self-certification. Now, my lord will kindly see page 55, 28. Bid evaluation and comparison of bid. 28.1, employer will evaluate. My lord, please note down. Employer will evaluate and compare only the bid determined to be substantially responsive in accordance with clause 26. So clause 26 I have shown, my lord, at page 54. Now, this is important clause. Now, before awarding of the contract at page 56, please see 30.1. Please mark this, my 30.1. 30. Employer right to accept any bid and to reject and all bidders. Notwithstanding clause 29, employer reserve the right. Now, my lord, I have shown who is the employer at page 31 and connects to page 62 is the chief engineer. Accept or reject any bid and to cancel the bidding process, reject all bids at any time prior to award of the contract, without thereby incurring any liability to affected bidders or any obligation to inform the affected bidder of so and so. Now, my lord, what has happened, my lord? The financial bid was, technical bid was opened. In pursuance to technical bid, my lord, there was a minute for technical bid evaluation held on 18th of December 2025, where lottery will find at page 275. Page 275, lottery got it, man. Now, this is minutes for technical bid evaluation. Now, if your lordship technical bid, Roman 3, my lord, the online technical bid were opened on 10/12/2025 at 14 hours in the office chamber of so-and-so in presence of bid evaluation committee members. Total 7 numbers of bids were received through online mode in portal so-and-so following bidders. Number 1 is Sanjay Singh. Number 2, 3, 4, 5, 6. 7 is the petitioner. Please mark 7, my lord. Now, if your lordship kindly see now, the online uploaded document downloaded, authenticated by so-and-so, upon verification of hard copy, it was observed all 7 bidders have submitted the physical documents in compliance with clause 12. Everyone has submitted. Now, evaluation of technical bid. Now, if your lordship turn to page 276, how they found after evaluation? Sanjay Singh, my lord, qualification information submitted is found to be ordered as so-and-so. Now, please look into 7 is the petitioner. Qualification information submitted bidder is found to be in order as per stipulation of RFP. Now, I qualified along with, out of 7 bidders, my lord, 5 bidders rejected. Now, the grievance of a particular bidder who represented representation was submitted before this technical committee, and how they observe on 18 December, after that a chance was given. See at 6, my lord, at 6 at 276. So-and-so N1, the annual turnover certified by CA does not match with the detail furnished in Annexure 3. That's what I have shown, my lord, in Annexure 3. It has to be matching with the financial document which they submitted along with the certificate of CA. Number 2, labor license is not valid as on bid due date. Hence, the bidder is liable to declare non-responsive as per clause 4.42 of the RFP. Now, 4.42 is page 35. If your lordship like to see page 35, 4.42. Please see 4.4 at page 35. The bidder shall have minimum average so-and-so, table below 15% so-and-so. So it mismatched with the auditors. Now, all others bidders, my lord, it was rejected. Mine, my lord, it was, and along with Mr. Singh, it was done. And if you see at 277, this is technical responsive bidder technically non-responsive, right, my lord? In view of BSc has decided. Now, please see the signature where the MOT was also present. All the executive engineer, financial and superintendent engineer, representative of regional officer MOT. Lordship got it? Now the chief engineer PWD. Now please turn to page 270. These are the three documents which is important. 278. Minutes of BWH meeting held on 9/1/2026. By that time, my lord, there was repentation which is filed by this Rana Construction. That is two repentation, 3/1 and 6/1/2026. Now this is 9 with regard to, kindly see my lord top, repent and receive for the work of so and so. Now if your lordship kindly see now, at in view of above, it was decided to open the financial bid of technical responsive bid on 7/1/2000. Meanwhile, representation was received from technically non-responsive bidder, namely Midas Construction and Rana Construction, requesting reconsideration of the technical status. Further, Rana Construction engineers has also raised complaint against the technically responsive bidder, so and so and so and so. They raised certain objection. Now, after detailed discussion, following decisions were taken. Rana Construction Engineer in the representation letter number so and so dated 6/1/2025 raised objection. This will be 2026, my lord. There is a typo. 6/1/2025. It is 6/1/2026. Anyhow, it cannot be 6/1/2025. Raised objection in non-film of so and so, so and so. Upon examination, the bid evaluation committee observed that Rana Construction themselves has not mentioned the name of the work in the integrated pack form. Similar minor error were also observed in the submission of some other bidder. As the integrated pack provided in the RFP is a draft and forms part of contract agreement to be executed by the successful bidder, BEC decided to ignore such minor formatting deficiency which can be rectified time of execution of the contract agreement. Accordingly, it was decided not to seek any clarification by any bidders on this issue. Now, for other points raised by Rana Construction against so and so, decided to seek clarification to bidders and decided to allow them 3 days time to clarify the stand from the date of issue of the letter from the chairman, BC, and decided failing of submission of such clarification within stipulated time will make them technically non-responsive. Further, BC decided not to accept any additional document with the clarification, which your lordship will find in clause 26.4, which I have pointed. Now, C3, my lord. Rana Construction in the representation letter dated 6/1/2026 have accepted they have submitted invalid labor license due to human error, which BEC decided not to accept. Hence, Rana Construction stands of technically non-responsive cannot be altered, and there is no point arises for seeking clarification from Ranacon regarding other grounds of disqualification. BEC reviewed the representation received from so and so. My lord, Midas is not because we will just ignore this. Now, my lord, Bill 280, they said of saying further BEC decided not to accept any additional document with the clarification. Now, these are, now this is at base 281. This is the last, my lord, 281. Minus for technical VW held on 21/1.
Yes, we are at page 281.
Yes, 281. 281. 281. Now, this is the minus for technical bid evaluation on 21/1/2026. Now, if your lordship now looks into it, the representation which was filed by respond number 7 was considered by this bid evaluation committee. Lordship has looked into it. 282. Kindly see my 282. Within the after fourth paragraph, within the stipulated time period, clarification has been received from so and so, that is Sanjay and UCN Construction. Bidders were not submit any clarification sought by letter dated so and so. Bid evaluation committee verified and examine the documents or technical bids of all the relevant papers. Deliberation of the bid evaluation committee are as follows. One is that qualification submitted is found to be ordered as per stipulation. Please go down to 7. This is the petitioner. Qualification information submitted bidder is found to be in order as per so and so. Now please see 6. That is response number 7. The annual turnover certified by so does not match with detail furnished with annexure 3. Labor license is not valid as on bid due date. Bidder has submitted additional document in support of so and so was not accepted, and the bidder is liable to declare non-responsive as per clause 4.42. My lord, is important. Is the rejection is 4.42 of RFP. Now, if your lordship turn to page 283, these are technical responsive and technical non-responsive. Now they decided, in view of the above, bid evaluation committee decided to open financial bid of a technical so and so. All the person concerned, including Moth, was also present here in this meeting. Now, this is the financial bid was opened at page 284. 284 among the out of 2 bidders, which number 1 is the petitioner. What you've got it, number 1. Number 2 is the other person who was qualified technically responsive, Sanjay Kumar Singh. Now, what has happened thereafter, my lord? We were waiting that now the work order, whatever it will be issued. 286, response number 7, had gone and filed a representation before the authority, that is MOTH, Ministry Road, Transport and Highways. They have filed a representation, which I have not found anywhere in the bid document that they are the authority to decide a representation. They cannot sit as an appellate authority. That's my first argument, my lord. They decided. Now kindly see how they decide. Same representation which they have submitted before BEC, where my lord, they have decided their person was also there. Kindly see 6.1. Now kindly see 3. Response number 7, my lord. 3.1 and 6.1 were received from so and so, so and so. In the representation, there is a 6.1/2026 contained a discrimination relating to annual turnover was minor in nature, and that a labor license issued occurred to him is human error. The firm also raised objection against so and so, so I referred to Ministry Circular dated permitting consideration of clarification for minor deficiency not resulting in material changes. Now, for a moment, kindly see the minor deficiency. Minor deficiency. Minor deficiency. There is a minor deficiency at page 273, my lord. Please see, my lord, what are the minor deficiency? Ministry of Road Transport and Highways. See, these are minor deficiency. That is A, B, C, D, which they are referring. And if your lordship looks into it, non-affixation of stamp, extension of validity, minor deficient power of attorney and BG, and so and so. My nowhere it mentioned the annual turnover mismatch with the CA certificate. That will be a minor now they have brought into it.
So tender process has been cancelled.
Cancelled. Now my question is one, whether they can sit as an appellate authority. Nowhere in the terms, it is only the employer who can take a decision. Now kindly see, they sat and they decide to cancel it, and at 289, only for in pursuance to the order that has been passed by MOT, they have taken a cancellation notice and issued by Chief Engineer. Kindly see this 9th of March. P3 2026, in pursuant to the decision they have taken, MOT, now they decide to cancel it. Now, my lord, one that they did is not the authority under the bid document. It is only the employer, and they have not cancelled directly. Technical bid open, responsive, I found it responsive. Financial bid, I was L1. Now he goes and filed a representation, and that representation was considered by BEC. How can, and this is who, my lord? An executive engineer. Kindly see at page 288. See,
Yes. National Highway.
Yes.
This is the approval of the competent authority.
Yes.
Yes, Mr. Nayak.
In this case, Lordship, I am appearing for the state respondent, Lordship.
Hmm.
And as your Lordship has seen, direction came from the ministry, Lordship. We only complied the direction that has been issued by the ministry, Lordship. So at this stage, Lordship will issue notice, Lordship.
Any fresh NIT has been issued?
Not
So
yet.
till today, they have not issued.
And who is for? So it will be, Mr. Das, come to page 21.
20.
First line itself.
21.
We have to look into that aspect. The Ministry of Road Transport and Highways through the Chief Engineer, PWD, NH Work, Public Works Department, the authority is engaged.
Yeah.
So what kind of authority each one of them exercise and what kind of delegation?
Lordship has to look into it.
Ah.
But apparently, that's why I showed who is the employer. Rejection,
Yes.
while accepting is the employer has been defined. And they have decided, and technically and financial bid was open. And how that representation of respondent.
Whether they can sit over it or.
Yes, correct. That's my point.
Paragraph 3 also, my lord, after that paragraph 1. Paragraph 3 of my lord, last line. Please note that the ministry, authority, executing agency reserves the right to accept or reject all or any of the bids without assigning any reason whatsoever. So, my lord,
Even
here-
then also, the
Here-
regions assigned herein are to be tested.
Yes.
my lord, reasons at page 287, my lord, paragraph 9. If I may read, my lord, why it was cancelled? Because so far as bid evaluation is concerned, my lord, the authorities were just the member. The chairperson of the evaluation committee was the chief engineer, PWD. Now here the issue is, my lord, regarding the cancellation of the entire tender process. Now, my lord, page 287, paragraph 9 is the reasons why the tender process was cancelled. If I may read, my lord, on.
Yeah, read.
Yes. So, my lord, the record reflected that the approach regarding this, my lord, seeking regarding clarifications, my lord, it was not
You
applied.
file your reply as soon as possible.
My lord.
File your reply. What kind of authority you can exercise under clause 3, clause 1 of the NIT? What kind of delegation you have made to the state authority?
Yes, ma'am, that is also
Right.
there. We'll file reply.
Your representatives were present, right?
Yes.
He was definitely exercising delegated power.
Yes.
His decision might be of the decision of the authority.
My lord.
If he exercised delegated power, that is a decision of the authority itself, NHI ministry.
But the decision to cancel
Let us-
the entire tender process,
Place all your cards.
that reserves with the.
Place all your cards. Even a cancellation process, not for good reasons, have been interfered with by the Supreme Court also. Heard Mr. D. Das, Learned Senior Counsel, listed by Mr. D. P. Vora, Learned Counsel for the petitioner. For Mr. H. Gupta, Learned Central Government Counsel for the respond number 1,
4,
2,
1 to 4.
3 and 4. Mr. Pina, Additional Advocate General Assam for the respond number 5, 6.
Only 5.
7
7 and 8 are private response.
Dosto. The respondent number 6 as an authority. Engaged by the Ministry of Road Transport and Highways, Government of India, published a tender notice dated 17/11/2025 for a contract work. Page 21. Post of. In the tender process, 7 bidders, including the petitioner, had participated. Post of. After opening of the technical bids in the tender process consisting of 2 bids, within bracket technical bids and financial bids, comma, the technical bid evaluation committee evaluated the bids in a meeting held on 18/12/2025. After evaluation, comma, the committee found 2 of the technical bids of the petitioner and another bidder responsive, and found the technical bids of 5 other participant bidders, including the respondent number 7 and 8, comma, as non-responsive to stop. Both the respondent number 6 and 7 had submitted representations before the committee for reconsideration of their technical bids and the technical bids of the petitioner and the other technically responsive bidder, comma, Mr. Sanjay Kumar Singh. The committee, after receipt of the representation, revisited the technical bids of all the bidders again, and reached in a meeting held on 9/1/2026, reached the same conclusion as reached in the meeting held on 18/12/2025. Subsequently, another meeting of the committee was held on 21/1/2026. When the committee verified and examined the documents of the technical bids and all other relevant papers, after deliberation, comma, oh no, দুখন meeting hall, দুখন meeting, 9/1/2026 and 21/1/2026, reached the same conclusion. The committee also decided to open the financial bids of the 2 technically responsive bidders. Of course, the financial bids were thereafter opened, and wherein the petitioner emerged as the L1 bidder. Full stop. By the impugned order dated 3/3/2026, issued by the respondent number 1, issued by the respondent number 3. The entire tender process has been cancelled, and it has been observed that fresh bids shall be invited after ensuring due adherence to the provisions of the RFP and other instructions. Post of Mr. Das, last year, considering for the petition has submitted that the impending order has been passed with an observation that the committee, while evaluating the technical bits, and considering the representations of the participant bidders, considering the representation of the non-responsive bidders, more particular, non-responsive bidder, more non-responsive bidders, that is the respondent number 6 and the respondent 7 had ignored the circular of the ministry. Circular dated 16/1/2026 of the ministry. Full stop. The entire tender process has been interfered with on the ground that the technical bits of the two bidders who were just not responsive, particularly on the ground that the deficiencies were minor and procedural and did not alter the basic character of the offer. Full stop. He has contended that the deficiencies of the two deficiencies committed by the two non-responsive bidders were material. The other ground on which the impugn order has been passed was that the financial bids were opened by the state PWD without prior knowledge of the regional, without prior knowledge of the ministry, despite pendency of examination and the examination of the representations at the ministry level. Referring to the minutes. Dated 18/12/2025 to 21/1/2026 and okay, 9/1/2026. He has submitted that the representative of the ministry was present in all the 3 meetings and the decisions were taken unanimously daring to open the financial bids of the technically responsive bidders. The L1 and L2, as indicated in the BOK summary details, was on the basis of the financial parameter submitted in the financial each of the two technically responsive bidders. So thus, the grounds shown in the impugn order dated 3/3/2023 for interference are clearly arbitrary and unjustified. To stop para the method with consultation. Issue notice returnable immediately. 2004/2026 as Mr. Gupta 1, 2, 3, 4, Nayak 5 and 6 No formal notice, extra copies, steps upon as per number 7 and 8. By speed post. Put ready within 2 working days. Having given consideration to the projections made on behalf of the petitioner, this court has found primacy force in the submissions. So it is therefore ordered in the interim that the respondent authorities shall not this process. Oh. Right, this process, this tender process. For the subject of till the returnable date. No.
2004.
Authorities shall file their response on or before the returnable date. Sealing material. It has. Okay, did you tell that? Tata to did you? Yes, Mr. Arvind.
Time being matters. Item number 59.
My lord, I have taken instructions, my lord. First of all, my lord, for inspection, engineer is here, my lord. But few things are there, my lord. The vehicle has to be placed to the dealer, my lord, because they cannot Tata Motors as such. They don't have office. They function from the dealer's office. So the vehicle has to be placed before the dealer, my lord. Second thing, my lord, is they have to produce the tax invoice so that, my lord, we can know that from which dealer they have purchased the vehicle, my lord. The initial sale, my lord. And next number, my lord, the vigilance of oil must be present there, my lord, because the inspection will be carried in their presence or whatever, whoever the parties is there, petitioner may be. And third thing, my lord, the RTO has to give cooperation with us, my lord. So far, the documentation and other things are.
What is the impugn order? What is the impugn order?
And lastly,
At 277, my lord.
Just a minute.
And the operative portion lordships will find at 279. They have given 5 reasons. Though the RCs in respect.
So what action they have taken against you?
Yes.
What is the action they have taken?
In view of the aforesaid, you are holiday listed for a period of 2 years from the date of issuance of this letter as per clause so and so, and the contract agreement of tender read with clause so of holiday listing, which are available on public portal.
Nothing further coercive.
No, already contract is cancelled.
No, that's it.
Yes.
Right. What are the kind of
One
consequence it will bring?
consequence is contract has been terminated. As a consequence,
Holiday, that is one, and contract terminated. And any other consequence is likely to be.
Naturally, because of
That is what-
list, I cannot participate.
That is one. That is one. Any further some forfeiture?
If the contract is terminated, necessarily performance guarantee on all.
That is what. That is what. Might be bank guarantee is there.
Bank guarantee.
You have submitted bank guarantee.
Performance guarantee.
Performance guarantee.
That's the bank.
That would entail cost again.
Yes.
If they invoke.
Right.
Right. Because it will be costlier.
Yes. Milord, can I make one submission, Milord? What my learned friend has said, if your lordships would kindly take the central rule for a moment, Milord. Motor Vehicle Act.
Because both are poking into the holiday listing and termination of the contract is almost.
Well, no, my lord, holiday listing would be as a consequence of the termination, and forfeiture of the performance or bank guarantee would also be the consequence of termination.
That is why I wanted to expedite at the earliest.
Yes, please have rule 47, my lord. Lord, our interim order which we'll be praying for at this stage is the number of vehicles would not be put to tender and no forfeiture.
What is the other order?
If a lordship would kindly have rule 47, my lord.
It order this is 47, yes, please.
47 1G. Roadworthiness certificate in Form 22 from the manufacturer, Form so and so from the bodybuilder, and in case of sales certification of the bus body built on a driveway chassis by bus body structure fabricator, certificate in compliance of 22B. Here we are concerned with Milord Form 22. Then if a lordship should kindly come to Form 22, if we are holding the same book, then the page would be 435. Now it is the original equipment manufacturer, my lord, who will provide this. It is certified that following vehicle complies with the provisions of the Motor Vehicle Act and the rules made thereunder, the model, commercial and chassis number, engine number, etc. So, my lord, pursuant to that, our vehicles were registered. Now, registration certificate is a public document. My lord, the onus is on the my lord, Oil India to disprove it. Prima facie, my lord, we have discharged our burden that our vehicles are registered and the registration certificate has been issued in terms of Section 79 of the Evidence Act. So it is not our onus to prove it. It is their onus to discharge, my lord, how they have taken this stand. And my lord, what is this vigilance report? We don't know. Somebody, some my lord, competitor may have filed some complaint.
That can be from the response only. At this stage, it is very difficult.
So therefore, my lord, at this stage, what I meant for
Are you ready to place the vehicles before the
yes, yes, why not?
Yes, Mr. You have to depute your officials.
Yes, we depute.
And Mr. Transport, you also depute.
Yes.
On a particular 2 day, we can fix.
Yes, yes.
My lord, only one thing left out, that the cost of inspection, my lord, because when the vehicle will be placed before the dealer, their technicians will go inside opening something, or so that some expenses are there. We will inform the expenses. My lordship has directed.
May have to be shared by both.
Yes.
That will be decided later on.
Huh? Yeah, whatever it is, my lord, I've got the instruction one, that's why I'm placing it, my lord. Either oil or petitioner or whatever.
Well, not our security money is already lying with the oil miller. Sorry, LCL.
No coercive action, no further coercive action. So far as after that, no consequential action.
Yes.
Yes, the vehicles are become mistakes. So the RTO, the DTO, my lord, the registering authority will be written for.
We'll be ready with the original registration certificate.
These days, you can do it online with video calling and all. Do it. Because of this later, perhaps page 263 letters about more petitions are coming or are on the way. Is it not? Heard Mr. K. Chorui. Please take your seat. Let me go. Senior Counsel estate by Mr. R.M. Deka. Mr. S.S. Roy.
1 and 4.
Mr. Roy, you have to be alert. There is Central Government Council for the respondent for 1 and 4. Mr. N. Borua, Standing Counsel. Indian Oil Corporation Limited for the respondent number 2 and 3. Mr. R.B. Goswami, Counsel on behalf of Ms. M.D. Bora. Okay, Mr. R.B. Goswami, Standing Counsel. Transport Department for the respondent 5. And Mr. J. Roy, Senior Counsel, estate by Mr. B.B. Sharma. B.P. Sharma, Learned Counsel for the respondent number 6. Full stop. Mr. Deka, what is your letter of date of acceptance, date?
6/4/2024, page 239.
Okay,
And work order is 25/4/2024, 216 page.
and work order dated?
25/4,
216.
Can you give the date
Yes,
of
yes.
LOA and work order?
Yes, yes, another link.
And how many trucks?
Yes, ma'am. Three
In three cases, 48 trucks.
No, 3 cases. Each order is to be separate.
Yes.
So can you modify the details
So we'll do that.
Yes.
in the other order passed
My lord.
in a similar petition?
Yes.
Okay. That copy did you?
Soft copy, get that, I'll take one.
Mr. Chodril and his senior counsel appearing for the petitioner has raised a number of contentions by referring to the registration certificates issued by the Transport Department, Government of Assam, as well as and circulars, a number of circulars of the MORTHGOI and the provisions of the Motor Vehicles Act and the Central Motor Vehicle Rules 1989. To stop by referring to the and has contended that the action taken by the respondent IOCL authorities in taking the decision to place the petition on holiday listing for a period of 2 years and to terminate the contract are clearly arbitrary and illegal. Full stop. Para. From the Shoko's notice dated 11/11/2025 and impugned order dated 2/3/2026. All are dates same.
Yes, ma'am.
It's
Please, to me, sir.
transferred at the Genesis to Genesis
Okay.
the source, the
Consequence to that, we need to provision. Where is the ancient? It speaks to the blacklisting.
the respondent IOC authorities had
79.
taken up the matter with the original equipment manufacturer OEM, that is Messrs. Tata Motors Sweden bracket, the respondent number 6 for verification of the chassis number and engine number. Full stop. In response, the respondent number 6 provided a communication dated 11/8/2025. Had provided a report as regards chassis number and engine number of 80 number of vehicles which have been placed before the respondent IOCL authorities for the contract work under reference. Post up. In the report, comma, it was mentioned that the report prepared on the basis of records maintained in the CRM DMS portal. Comma, it was reported that out of 80 number of vehicles, records were found as regards says of 5 number of vehicles. Full stop. As regards the remaining vehicles, the report mentioned that in case the CCs were very old, in that event, such records might not be available in their CRM DMS portal. Full stop. It is a customer relationship management.
Yes. Yes.
CRDMS stands for Customer
Relationship Management.
Dealer Management System.
Yes.
Full stop. From a cursory perusal of the report of the respondent number 6 does not privacy emerge that there was any manipulation of the engine number and chassis number of the trucks presented by the petitioner before the IOCL Limited for the contract work under reference, which is fraudulent in nature. Full stop. But observing that since the respondent number 6 had confirmed that the chassis number of the trucks in question were not available in their internet records, though the engine number and chassis number of the trucks match with the registration number of the trucks in the records of the State Transport Department. The impugned action of holiday listing and termination contract has been taken. Full stop. Para. On a query made to Mr. Law and a senior counsel appearing for the respondent number 6. Before them. Issue notice returnable before bill koridiyo. As all the respondent issue notice returnable before bill koridiyo. 6th of April.
6th of April. For inspection.
No. Issue not returnable 6th of April.
Yeah.
Before you.
Yes.
Firstly, let us see the report.
Yes.
We'll see the report. As all the respondents are represented, the notice is made returnable on 6/4/2026. Having regard to the issue involved, this court is of the considered view that the trucks which against which the adverse action have been taken by the respondent IOCL authorities. An inspection of the same physical, a physical inspection was seen shall be made by the competent personnel from the respondent number 6 at a designated place on a scheduled dates. Full stop. Yes, tell me 2 dates.
But not to, I think.
Dealer designated place. Tell me.
Okay, my.
You said.
Dealer, 3-4 dates, my lord.
No, 2 dates will do. Today is
70 trucks, 75 trucks, my lord.
18. 18. No, petitioners. 48.
48.
Today is 18. They have to bring the truck also.
Yes.
Dealer is the Kamakha.
We will communicate, my lord. We will communicate to the dealer's name and we will communicate to them that to place the vehicle to that.
Okay, to Mr. Deka.
Yes.
By tomorrow.
But day after tomorrow, let you matter because the after send us order copy and other things, my lord.
Having regard to the fact situation, this court deems it fit to fix the date of inspection of the trucks 26-27?
Yes.
Yes.
On 26/3/2026 and 27/3/2026 at the designated place, which will be intimated to the learned counsel for the petitioner by Mr. Sharma, assisting Mr. Roy, by Mr. Sharma, learned counsel for the respondent was 6 on 23rd. 23rd Friday by 20
by
2026. Full stop. Mr.
Other sides as well, we also.
Yes.
My lord, that
Everybody.
instead of 26, 27, let it be from 23rd to 27, so that we have flexibility of directing them to produce the 48 trucks, my lord.
Okay.
23 to 25 in between, we say that.
Okay, from 23rd to 27.
Mine. That will be
From 23rd, 5 days.
5
days.
My lord.
Okay.
Space constant would also be there.
Yes.
The respondent transport department, Assam, respondent authorities in the transport department, Assam, the respondent IOCL authorities shall ensure to depute competent officials, or what is the word?
Vigilance officer, my lord, because the complaint is.
They
will decide.
Yes.
Competent officials shall ensure the presence of competent officials on those days, on the date of the inspection, dates of the inspection, at the designated place, which should The designated place will be informed to the learned counsel for the petitioner and the respondents by the learned counsel for the respondent number 6. By
20th month.
2020. After comprehensive inspection of the vehicles placed on the dates of the inspection, the respondent number 6 shall prepare a report.
And submit it, my lord, on the next day, 6th.
Shall prepare a report to place it before the court on the returnable date.
But returnable date is 6th is after Sunday, Monday, my lord. Let it be on 8th, my lord, so that I have 2 working days.
Then it will be very
Or
difficult
7th.
for us
Let it
to
be
also.
6th or 7th.
It will be very difficult. It will be
Difficult,
taxing on me also.
6th.
6. On 6. The findings of the transport department shall also be placed in the form of a report on 6/4/2000.
In the meantime, the vehicles will not be put to tender, my lord.
Full stop. Okay. So Tata and transport.
One more thing left out on my lord, tax invoice.
Some easy like a tax.
The petitioner shall place all the vehicular documents,
Including tax invoice.
Insurance, tax.
Including
everything.
tax invoice.
including
That is important.
and their disposal before the officials of the
Respondents.
before the inspecting officials. At the time
tax invoice.
the trucks are placed for inspection.
tax invoice road tax.
No, road tax no. গাড়ি কিনে দিয়ে tax
Original
unless we will not be knowing that which dealer.
First, full stop. The official.
The original tax invoice we cannot.
The officials of the respondent number 6 shall ensure
It will.
whether there is any kind of tampering with the chassis number
And engine number.
and the engine number of the trucks placed for inspection.
Yes, sir.
You are the best person.
Yes.
You will come to know. You know where the
Only
chassis
thing is,
number
my
is inscribed
That is correct.
and whether there is manipulation.
That is correct, but tax invoice, we come to know
The
that.
original tax
From
invoice
this-
you don't have.
You prepare whatever you prepare.
But last thing about the cost, my lord. Cost of the inspection, my lord. Cost of the inspection.
Indian Oil Corporation.
It might be more because if your report turns out to be the genesis,
No, but the
then cost will be borne by you also.
that is correct, my lord. I'm not.
Because of their report, these all.
The cost
But
cost.
it is to be done by dealer, my lord.
incurred. No, if your report turns out to be very
Whatever it is, my lord. If done, we will face the consequence, my lord.
okay. The matter the cost to be borne
No.
for such inspection is subject to further orders of this.
Yes.
Is made subject to further orders of this.
Well,
You place your cost. The cost,
Okay, but
right? You
We
place the
place-
cost
we place the cost.
before the court, then we'll decide petitioner and IOCL.
Yes, depending upon the outcome of the report.
Outcome. Right. If who are at fault, we'll see. Right. Para. It is ordered, having regard to the fact situation, facts and circumstances of case, it is ordered in the interim that the respondent IOCL authority shall not take any further coercive action against the petitioner.
Including
And
issuance of tender.
shall not induct any truck on permanent basis. Permanent basis. Work has to go on. Permanent basis. in to replace, in replacement
Of the
of the
petitioner's
trucks
vehicle.
of the petitioners,
Deeply obliged.
right? Till the returnable date. So work has to go on.
Certainly. End of the day, these are essential.
Anyway, petrol, LPG, all are scarce now,
Absolutely.
and it has to go on. I am
And
facing
instance-
LPG crisis at my own home.
Unless the war stops, Milad, I think everybody will feel it. Maybe another couple of days.
So, Mr. Roy, do it. And designated place. Whichever is the best.
I'll do it.
Whichever is the best.
That. My lord, I'm taking your liberty, my lord. Item number 65, my lord. Maybe after a week, my lord. I've taken the consent from the other side. Oh, is there, my lord? Item 65, my lord.
On you're for?
I'm for respondent, my lord.
After Bihu.
3 and 4.
After Bihu. After Bihu.
Lordship, before Bihu, Lordship.
No, no,
The urgency is there, Lordship.
admission matter not possible.
No, pleadings are completed.
JM Gogoi for the petition is present. Mr. J. Roy, when a senior counsel is stated by Mr. B.B. Sharma, appearing for the respondent.
3 and 4.
3 and 4 has been a prayer for adjournment. To stop. And the praise allowed, release the case on sales.
24th April, 2404.
Mr. Deka, you give the details, right?
Item 62.
22 more na.
Yes.
Yes, please, Your Honor. Before I take your lordship to the petition, I'll very briefly summarize the point. Milord, the FCI issued an NIT inviting bids for transportation of rings from Gujarat, no? From Gujarat side to Assam. So the petitioner was one of the tenderers, and ultimately he was found to be the lowest, and they have selected him. The tender terms required that the person who is selected within 15 days, he will give a bank guarantee and some other security deposits. As far as security deposits are concerned, there is no problem. The problem arises with regard to the bank guarantee. Bank guarantee was to the extent of about 70 lakhs. The respondent fixed the date as 13/1/26 for depositing that bank guarantee. We, Milord, went to the bank and our account was debited for the said amount on 13th, 13/1/26. But the system of the bank developed some technical difficulty for which they could not send the required message to the persons who are required to be informed, FCI authorities. 14th was holiday. But bank managed to issue a bank guarantee on 14th from the bank, from their back office, and on 15th we gave the bank guarantee, submitted the bank guarantee and informed. And they accepted, there was no problem. Subsequently, a few days thereafter, they issue a notice asking us as to why the settlement should not be terminated, because we did not give the bank guarantee within the time, namely by 13/1. We submitted our reply. Nonetheless, they terminated our contract. on 23rd February. That is, will not be, settlement was cancelled. Our fixed our security amount were forfeited. The bank has the bank guarantee has been encashed. We have been debarred for 2 years. And finally, there was a threat that your MSME license, they are not the authority.
Who are they?
MCI, they have no jurisdiction to disturb that. But
Is it mentioned there?
they mentioned, they took the trouble of mentioning that we will take all steps to have your MSME license cancelled. The venom is split. Absolutely.
So, have you heard?
Huh.
Suppose it is a failure. Let us assume.
Yes.
Because you fail to meet the deadline.
Correct.
There will be bid security, bid money, EMD. Perhaps EMD was
Earnest money was there.
Second is security money.
Amounts are there.
Right. Suppose in case you have failed to deposit the security money.
Yes.
Whether, but suppose you did not deposit. You did not deposit. Instead of depositing, you did not deposit. What would be the consequence? Forfeiture of earnest money.
Correct.
If you fail to deposit the security money, but deposit it belatedly, how can that be forfeited?
Encashed.
And encashed. This is where is the condition? Suppose he had failed, Mr. Singh?
Yes, ma'am.
He had failed to deposit the security amount in time. What is the consequence?
Like it is there in the forfeiture clause, that is at 11B, page 56.
Let us see.
Summary termination, page 56, my lord.
Termination. No, contract is not yet.
It's been terminated, my lord,
No,
because they have failed to deposit the bank guarantee
contract
within
is
the
not yet
stipulated time.
executed.
Terminated.
No, contract has not been executed.
No.
No, letter of acceptance was given. They were asked
Letter of
to.
acceptance was given.
That amounts to contract.
Subsequently, it will be followed by an agreement. That is different. But our settlement itself, our work order in our favor has been.
Let us see the work order.
Yes. 123, my lord. Just give me a minute. Letter of acceptance of road transport contract X so and so on regular basis for a period of 2 years. Reference so and so. Please refer to this office tender number so and tender submitted by you for road transport contract X Salspada to Badarpur Ghat via Webrings on regular basis for a period of 2 years under divisional office Silchar through GEM portal with so and so, dated so and so. Your quoted rate of 449 per metric ton for entire distance for transportation has been accepted by the competent authority for a period of 2 years. You are advised to furnish the security deposit comprising of a sum of equivalent to 5% of the estimated value of contracts submitted electronically through NEFT RTGS amounting to 23,55,000 only. This we have done. There is no dispute on this. However, the contractor at his option may deposit 50% of this amount that is 2.5 within 15 working days of acceptance of his tender as initial security deposit at the time of joining the contract, while the balance 50% may be paid by the contractor by deductions.
Now come to page 42.
Yes.
Page 42.
Yes, your lordship is right. That's the point.
Page 42, Roman 4.
Correct. Yes. In the event of the tenderer's failure, after communication of acceptance of the tender by the corporation to furnish the required security deposit under clause 7(1)(a) by the due date or requisite security deposit in the form of bank guarantee under 7(1)(b) and 7(1)(c), including extension period applicable to submission of bank guarantee only, his contract shall be summarily terminated, besides forfeiture of the earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and law.
That will be taken care of last. But where is the question of encashment of bank guarantee?
My lord, may kindly come to page 53, clause F of 9.
No, suppose he failed to deposit a bank guarantee at all, security amount.
He will be terminated.
No,
the contract
he submitted it beyond the last date.
Yes,
Meaning thereby it is as good as non-submission.
Yes, my lord.
How can you encash the bank guarantee?
I don't
for
think it
security
has
deposit?
yet been encashed, my lord.
Yes, yes, it has been.
It has been encashed.
We have said that.
It is as good as non-submission, failure. Only earnest money deposit can be forfeited.
My lord, may kindly see the page 53, my lord. Further, clause 9 under security deposit, Roman 9 F, page 53, my lord. Page 53. May I read it, my lord? In the event of the tenderer failure after the communication of the acceptance of the tender by the corporation to furnish the security deposit under clause 7(1)(a) by the due date or requisite security deposit in the form of bank guarantee under 7(1) and 7(1)(c), including the extension period, his contract shall summarily be terminated beside forfeiture of earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recoverable from the contractor without prejudice to any rights and remedies of the corporation under the contract and the law. The contractor will also be debarred from participating in any future tenders of the corporation for a period of 2 years after the completion of the prescribed period of 2 years. The party may be allowed to participate in future tenders of the FCI, provided all the recoveries have been affected by the corporation and there is no dispute pending with the contractor.
Nothing. It is as good as...
I'm sorry, my lord, it's 11B. Page 56, my lord.
You are getting into more difficulties.
My lord, page 56.
You are
one last clause.
difficulties. 11.
Clause. 11, Roman 11, summary termination, subclause B at page 56, my lord. The general manager shall also have, without prejudice to any other rights and remedies, the right in the event of the breach of the contractor of any terms and conditions of the contract to terminate the contract forthwith and to get the work done for the unexpired period of the contract at the risk and cost of the contractor, and or forfeit the security deposit or any part thereof for the sum or the sums due for any damages, losses, charges, expenses, or cost that may be suffered or incurred by the corporation due to contractor's negligence.
Mr. Singh, till he signs that
it is
no, Mr. Wait a minute. Where is that? Till his where is that letter of acceptance?
Letter of acceptance.
123.
Along with the bank guarantee, he has to give the MTF, duly signed.
It is
Right.
signed, the signed MTF is uploaded in the,
No.
in the
MTF,
JAM portal. Thereafter,
MTF,
he has to submit, yes, my lord.
yes. Request to submit original hard copy of MTF.
Hard copy of the MTF.
Right. You are referring to page 50.
I was referring to page 56.
56. He assumes the role of contractor after all formalities are complete. Till then, he is a bidder. This speaks about contractor, negligence, unworkmanlike performance. This is subsequent to the contract. There is no formation of the contract in the case till date.
My lord, that,
And if he
that may
fails
not,
to
yes, my lord,
submit,
that may not come into play right
if he
now.
fails to submit the performance bank guarantee or within the last date, it is as good as non-submission. That cannot be forfeited or encased or invoked. Who is the clause? Are you sure?
Yes, we have made that statement.
Where is that order? Impugn order, Mr. Bora.
The termination order.
Termination.
Page
Page 159.
139.
189.
189.
Yes, please. 189.
And busy invocation is 197.
This concept I don't find. $180?
9. Termination of.
No, busy.
Invocation 197.
197. How can you invoke this when you did not accept it? Huh?
And at page 192, your lordship sees the last paragraph. The one I was mentioning. Corporation will also take up for cancellation of the license of GV Logistics with MSCD
I
authority.
think it is written in the clause 14(4).
True, but
Mr. Singh.
Yes, my lord.
So far as forfeiture of earnest money, if it is assumed that he has paid. Forfeiture of earnest money, yes, it is as per the terms of the contract. Debarment.
We have issued so cause notice. Thereafter, we have.
Right.
And
the law has been settled now.
Yes, my lord. That so cause notice has to be issued.
No. Another law. Mere failure on the part of a bidder
that will
not
your
entail
will
the
examine
facts and circumstances of the case, but you please explain. Or with a cost, I'll direct. Why encasement? Because that is visited the petitioner with heavy cost.
Encasement of the bank guarantee.
Yes. How much?
65,000.
If your lordship will take after some time, I may get confirmation.
Who is the power? Who is the power?
Yes, my lord. After a few minutes, my lord.
If your lordship will just kindly turn to page 130. I mean, see the absolute arbitrariness in the whole process.
No, but those are subject matter of examination.
Yes.
But so far as bank guarantee, if there is no power for invocation, yes, EMD will not entertain at this stage. Will proceed further regarding debarment. Will examine. Law is that otherwise mere failure will not entail debarment because it amounts to civil death.
No.
But so far as this is concerned, this appears to be privacy.
Let me take
beyond the bound.
That's 5 minutes.
130, Milord, page 130.
MSME.
No, Milord, the
invocation.
HDFC's own letter. Milord, what is our fault? Milord, we have gone, our account is debited, they couldn't send it because of the failure. And the next day it was Bihubanda in Assam. Page one.
Termination of contract will examine.
No.
Termination of contract,
But
whether
they have issued a new notice now. New tender, that is below.
take a call.
That will come, last date is when?
26th.
26th.
That will be to their, my lord, the termination with risk and cost, my lord.
No, no, how
That
can
will,
it?
that will be examined by your lordship after filing our
Okay,
affidavit.
find out. We'll examine further after some time.
Yes, yes.
Obligement.
Item 64.
Yes, what is this?
LOI has been cancelled, my lord, by the APDCL and fresh tender has been issued.
May I please, your lordship? I am coming to write from the impugn order, that is S, your lordship, whereby the LOI has been cancelled.
Page
Page, I am coming to page 371, your lordship.
371.
Yes, your lordship. This is the impugn order.
E-tender was floated.
Lordship. It is a speaking order dated 9/3/2026. E-tender was floated by NIT number so-and-so Kamardanga dated 11/9/25. Lordship, this is very important, 11/9/25. The work construction KV number so-and-so, and full trunky mode. The price bid of the above mentioned work was opened on 2/2/26 and MS Wind Power LLP was found to be a L1 bidder. Accordingly, the firm was issued a letter seeking justification of abnormally low bid ALB, while letter number dated so-and-so 2/2/26, wherein bidder was also requested to submit supporting document with respect to Annexure 1E for calculation component, a bid capacity, duly signed by an officer not below the rank of DGM prior to the issuance of the work order. Subsequently, thereafter, your lordship, letter of intent was issued to MS Wind Power LLP on 5/2/2026. However, due to non-submission of requisite supporting document, the firm was again requested to submit the supporting document with respect to Annexure 1E, white or letter number so-and-so, Kamardanga dated 7/2/26, so that the work order could be issued. In response to the APDCL's letter, Wind Power LLP submitted supporting document in respect of Annexure 1E for calculation of component A, bid capacity. Upon scrutiny by the audit section, it is observed that the supporting document and Annexure 1 is submitted by the bidder. The bid capacity calculation was flawed. Accordingly, a letter seeking further clarification was issued to MS Wind Power Infracom, white letter number so-and-so, dated 19/2/26. However, on further scrutiny of the said document by committee constituted white number so-and-so, dated 25/2, it was observed that the document submitted by Wind Power Infracom could not consider for calculating the parameter A bid capacity. In view of the above fact and findings, the LOI 5/2/26 issued to MS Wind Power Infracom is hereby cancelled. After due consideration of the finding of the committee and the relevant provision of the bid document, it is hereby decided that the tender work of the work construction 33 kV dedicated feeder project Kamardanga and so is stand cancelled. In this regard, bid was called sometime in 25. Clarification has been sought for. We have repeatedly thrice we have given a clarification, and therefore thereafter we have been asked to give this bank guarantee. And in view of the low bid capacity, L1, abnormally low, we have been asked to give an additional contract guarantee. We have provided to them on 10. APDCL has already made a confirmation from the bank. Yes, they have executed the bank guarantee.
What is Annexure 1E?
Yeah, I am coming to that.
No, what is that? Just a... It is clear, only a letter of intent was issued.
Yes, Your Lord.
Work order was yet to be issued.
Yes, Your Lord.
Right. Ball was in the domain of the tendering authority.
Yes.
And they have asked for clarification, again clarification, did not reach the satisfaction. So recall the tender process.
But the thing is that they have accepted it.
No, from the speaking order, it does not emerge.
I'm coming to that. I may be given some time, Your Lordship. They have admitted the finance. Earlier, they have accepted 11 out of 11 bid. I was also, they have accepted.
Maybe.
Earlier also on the same bid capacity. I have worked under them from 1959, Your Lordship.
Where is your expertise?
I'm giving that. I'm coming to that, Your Lordship.
If by sitting here, I can get expertise on it. This is a letter of intent, no work order. What right you have?
But the thing is that because letter of intent they have given, I have given them, they have asked for
What is
additional.
letter of intent? See the word. Subsequently, letter of intent was issued 5/2/2026. However, due to non-submission of requisite supporting documents, the firm was again requested to submit the supporting document with respect to Annexure 1E by letter dated 7/2/2026 so that the work order could be issued.
I have
So,
submitted the document. Submitted the document.
They found it.
Annexure M. Annexure M. Page
What is
number 143.
What is 1E? What is 1E? Annexure 1E?
I'm coming to it. Page number 94.
94.
Page number 94. Annexure E. They are asking for the additional.
94?
Page number 94.
That is.
With reference, this is the letter.
This is Annexure 1E.
1E, our is Annexure E only, Lordship.
This is something 1E. What is 1E?
Main. That's one is a part of the bid document, my lord. How to ascertain the bid capacity.
Yes.
Yes.
Somewhere it is there.
It's not there, my lord. Bid here has not been annexed, my lord.
Oh.
But I have a copy, my lord.
I have taken the leave because it is a bulky document.
Right.
I have taken the leave in the paragraph that as and when required, we will produce because it is not disputed. I have that document, bid document.
Yes, Mr. Pathak, your trucks are also should be placed there.
And their condition is that.
Where is Annexure E? Page?
That's marked as Annexure 1. There is a flag here.
You have given.
It is for bid capacity.
Yes.
Bid capacity. And in the same bid capacity, I worked under them on number of occasions. Number of occasions, which the detail I have given from Annexure.
What is the clause pertaining to Annexure 1E?
That my lord finds that designation is not there actually, my lord.
Tell me clause.
It is in the section 2. Section 2, Your Lordship.
Clause C, my lord.
Clause C.
5C.
Who meet the minimum qualification criteria mentioned
Must have
against the
experience of
technical
swears.
field will be qualified only if the bid capacity time is more than the
Itu di unike termina.
Yes, madam, put the figure in the formula and tell me.
Yes.
Put the figure
Yes, Your Lordship.
in the formula
Yes, Your Lordship.
and tell me.
Prior to that, we have worked under them more than 10 crores.
We don't need that. Put the figure A and 2 and B. A and B and work out
2 minus B.
2 minus B. Put the formula. Put the figure in the formula
That
and
I
place
will-
it before me.
That I will have.
That's
to-
all.
But the thing is.
And your bid has been not accepted. Has not been accepted on the ground. Annexure 1E.
But the
that-
evaluation committee has allowed me to. They have selected me to give the bid. I have been selected.
Giving bid is another thing.
There-
And working out bid capacity is another thing.
But it has been given earlier, right from the beginning, we are.
Oh, tell me the figure. It is very simple. A into N into B, 2 minus B.
Yes, Your Lord.
That's all.
245, page number 245.
Have you worked out in your petition?
I have not worked out, but.
And
the
then how
paper is
can I
there.
work out for you? And they have rejected your bid only on that ground that you do not have the bid capacity as per the formula annexer 1E. You have to put the figures in annexer 1E, then A, B, and N are to be taken out from them and put in the formula to find out whether estimate.
We have already clarified them thrice and.
No, I don't calculate, I don't sit here in an examination to work out a mathematical formula. Have you understood?
Kindly give
You
me that
you
one
give
day.
the figure,
You kindly give
you
me
put
one
in
day,
the
I will
formula.
put the figure.
You put the formula in the formula, tell us, then I'll ask question to Mr. Goswami.
One day may kindly be given. One day.
Yes.
If I may be allowed to, page 87 is the calculation given by the petitioners, madam. 87. Page 88 is relevant, madam.
It is there already.
Page 88, my lord will see.
I've seen.
This is the chart, my lord, 2023-24. Their calculation comes to 26 crores. They are harping on, my lord, 2021-22, 1 crore 30 lakhs.
This one.
Sorry, 130 crores, my lord. 53 lakhs 27,000. Next, my lord will kindly see below, my lord. Figures to be mentioned in the column shall be supported by relevant copies of work order, letter of acceptance, as well as corresponding completion certificates issued by the officer not below the rank of CEO, DGM, superintending engineer of electrical utilities. So, my lord, their calculation comes to this, my lord.
Okay.
But difficulty is that, my lord, what they have done, they have, my lord, submitted certain work orders of a different company. It's a LLP, my lord. They had a company also. They have relied on those. If they are relying on those, my lord, they have to show us, my lord, subleasing certificate, my lord, that has been subleased. And for that, my lord, employer needs to certify. We are the employer, my lord. They're relying on some earlier work allotted to a different company, which somehow they are connected, my lord.
We have worked under them. We are working.
But it's not a, this is not a tender in joint venture, my lord.
It is not sublease.
This is not a tender in joint venture. The LLP has come and they are trying to take recourse to some work done by the company, which we cannot accept, my lord. So that's why, my lord, their value, this value is not accurate for us, my lord.
So this figure they have calculated is not acceptable.
Not acceptable.
So you sought clarification.
Sought clarification. They
and you have not reached the satisfaction.
Yes, because
they have the bid capacity.
Because it says, my lord, as I have already read, figures mentioned in column A shall be supported by relevant copies of work order. There is no work order in their favor.
Yes.
And it has not been subleased also to them with our concurrence, my lord. So that is why it has been rejected, my lord.
Time, there is no question of sublease. We have worked under APDCL. I am giving the lordship all the detail, 149.
Let them participate in the fresh tender, my lord.
Because the price bid has already been disclosed.
Madam, your bid was not accepted. It was only a letter of intent. Right. And from the nature, sometimes letter of intent is a work order itself. I examined it. No. Letter of intent is to be followed by work order. Meaning thereby it is only letter of intent that we are inclined to enter into a contractual relationship with you, provided we derive satisfaction from the clarifications received from you.
This is not the first instance, your lordship.
Oh, we don't go by history.
No, we have given them the detail.
I am Kumari, learned counsel for the petitioner.
Then I may be permitted to clarify, your lordship.
Oh, you clarify. If you seek time,
yes, your lordship.
I'll grant you time. Clarify. So that I can ask Mr. Goswami.
Yes, your lordship.
Learned counsel for the petitioner and Mr.
And my concern is that, your lordship, the 23 is the last date for accepting the fresh tender bid. It has been started. There may be a multiplicity of litigation in the event of they will take the security.
We will refund the bank guarantee, my lord.
It was, you never asked for bank guarantee because bank guarantee was to be deposited when the contract is executed. To make good a case, my lord, before execution of contract, they have deposited the bank guarantee. We'll refund it, my lord.
In LOP,
In the previous case,
We'll refund it, my lord.
no, they have asked us to deposit the bank guarantee.
We'll refund it, my lord.
And because we have to spend a huge amount, your lordship, in depositing the bank guarantee. It is in crores.
these are the risks associated with for a bidder. And Mr. P.N. Goswami.
I may be given some time to clarify your doubts.
Okay, for all the respondents.
For you Ajay, for all the respondents. And it's a statement by Mr. K.B. Pathak, Granite Council, Standing Council, APD sir, for all the respondents. So stop. Okay. How much time you need?
Kitna time length?
In order to substantiate her
It is on
contention,
27.
SPB has sought listing of the case after which
27th of March, your lordship.
March, Wednesday. Wednesday?
No, 27.
27.
Friday,
The
ma'am.
case only on 27.
Obliged.
Sure.
You need this document?
Yes. Obliged, ma'am.
Yes, last. I don't know who. It will.
Your lordship has seek apology.
No, that half one. Mr. Goswami. Just a minute.
Yes.
I'm sorry, my lord, that has been that has been invoked, my lord. Bank guarantee has been
Have we made
well, your lordship may direct it, we will refund it, my lord.
Huh? Okay, will you represent all the respondents?
Except one, my lord, Union of India.
Okay. Somebody will represent. Right. So if it is not within the thing, this should be returned. And other issues we are examining.
Other amounts.
Termination of the contract,
Yes,
earnest money,
yes.
and debarment.
And security.
And
deposit.
risk and cost.
Security deposit one is.
Risk and cost will be there. We will not touch upon that.
My lord.
So far as encashment of a bank guarantee in the interim order will observe.
My lord.
Right.
My lord.
And since the issues are serious, so we'll also decide very fast.
Yes, madam.
Yes.
After view vacation, madam, we'll
You
try
have
to file our
You
affidavit.
have to
before-
file and we'll observe that
And
further you have to file response.
Yes, madam.
In the event response is not filed, consideration of further interim prayer will be kept.
We will file by 10th of April.
consideration.
We will file by 10th of April.
Milord, may I only point out this, Milord? The new notice has been issued. After all this, Milord.
It will be subject to the further order.
Yes,
No,
madam.
Milord, that last date will be 26/3. So it will complicate matters unnecessarily since your lordships are going to hear the matter quickly. Don't, Milord, kindly keep that in abeyance for the time being.
This is food distribution.
TDS system will be hampered, my lord. Admittedly,
No.
they have deposited bank guarantee beyond the date, my lord.
No, temporarily they are doing it, that is different. They are not in distress. If at all, Milord, the first process where we succeeded, it has come to a culmination. If that is their grievance, then I should be the person who should be, Milord, supplying for during the currency. And this notice of termination which has come subsequently, that the last date for filing comes on 26.
Mr. Goswami, having looked at the thing, I have the interim prayer that is will be bit. Ultimately, it is a failure.
No, Milord, kindly see the letter at 1:30 of the bank. We have not failed.
No, ultimately, who has to give it to the employer?
True, but
to carry the physical thing, or it is a digital thing?
digital, my lord, they will inform.
No,
That
my
is
lord,
the
physical,
requirement.
my lord.
Of course, your terms of the conditions say that.
Ultimately, who is the person who has to deposit it to the
We
employer?
have deposited, the bank on 13 could not do because of their own system has broken.
Is it the way?
Kindly turn to page 130, my lord, that will clarify the entire position. This is a bank's letter, my lord. Clarification regarding delay in issuance of bank guarantee. This is to inform you that the HDFC Bank had processed the request for issuance of a bank guarantee with BZ number so-and-so for tender number so-and-so on behalf of our customer, this is the petitioner's name, in favor of Food Corporation of India. Due to certain technical system related issues at the bank's end, the bank guarantee could not be processed and issued on intended date before the close of the banking hours on 13th January 26. Consequently, the bank guarantee was issued on the next working day on 14 January 26 in back office of HDFC Gauhati. However, the effective date of the bank guarantee is 13 January 26. The liability of bank guarantee starts from 13 January 26 and risk of said BZ is covered from 13 January 26. SMF code 7027 of the BZ also states the date 13 January as well, which your lordships will find at page 141. So it is absolutely made clear that they are not suffering any difficulty because of the failure of the bank to inform them, because it has been made effective from 30th January. So their interest is absolutely protected. That's why I'm saying, my lord, it is absolutely an arbitrary act, and all of this is taking place, there is a reason. In an earlier proceeding relating to another tender.
Then, Mr. Singh, you file your reply and shall not finalize the subsequent process.
Yes,
Will not pass the order on BZ then. Will not pass the order on BZ.
Yes, ma'am. Will not
Because,
finalize the tender.
Because if I pass that order, you will be returned. But you have accepted it. You have accepted it.
Yes, yes.
So, encashment of the bank guarantee.
They have got it.
So you have
Therefore,
used it.
my only request will be this, my lord.
Meaning thereby.
No, my lord,
Meaning thereby you have
the
accepted
contractor
it.
is bound by the tender, my lord. Tender document.
No, if he had failed by 13, he could not have utilized it.
He has failed
And
to
you have-
deposit by
you have
13.
utilized
Because he has deposited on 15, my lord.
Don't act
It's
violently.
beyond prescribed time, my lord.
Okay.
No,
Why don't
in
you
that
make
case,
130?
your power is restricted to forfeiture of the EMD. But what you have done, you have got hold of the security amount also.
Everything.
Right. Even if it was submitted with delay, you have accepted it. And at the same time, you have gone against him.
My lord, then early disposal of the matter, my lord.
Huh?
Early disposal of
That's why I'm saying, my lord, these amounts which are with them.
We'll proceed with the tender, we'll not finalize it, my lord.
My lord, may I only say this, my lord? The amounts taken over, they, my lord, may not be utilized by them, because suppose I am getting.
But they were with the bank guarantee, and they have.
No,
they have
already-
encased it.
Yes,
That-
that's why
they
I'm
have encased
saying,
it.
whatever has been now recovered from me, that should be put in a bank, my lord, during dependency, that's all. It will abide by what your lordship decide ultimately.
Extended by Mr. B.P. Bora, Learned Counsel for the petitioner. Mr. B.K. Singh, Learned Standing Counsel FCI, for the respondent number 227. Anybody, Central Government Council? Para.
My lord, 2 to 6, 7 is bank.
Okay, 2 to 6.
Already responded.
Issue notice. Returning on 22nd April 2020. As Mr. Singh has appeared, accepted notice on behalf of the respondent number 226. No
He is
problem.
appearing
Notice,
for
extra
2 to
copies.
6.
The land council for the petitioner shall furnish a copy each.
One.
Furnish a copy of the petition along with annexer to the land
Union
of India for the within 2 working days. For service of notice upon the respondent number 1. The petition shall take stage for service of notice upon the respondent number 7 by speed post within 2 working days. Full stop. Para.
Union of India, can we give it here to the council? The Union of India, already copy has been given and his name is shown in the list.
Extra
So,
copy.
Extra copy will give.
Extra copy. By a notice inviting tender dated 29/8/2025, comma, the respondent number 2 invited online tenders under 2-bid tendering system at GM portal for appointment on regular basis for a period of 2 years. For appointment of road transport contract. Most of the estimated value of the contract was 4,87,000, and the EMD mentioned in the tender notice was 9,66,000. Post of. The petitioner participated in the tender process, and having found the bid of the petitioner technically qualified, comma, the financial bid was opened and the quoted rate of rupees 449 per MT for entire distance for transportation was considered and found L1. By a letter of acceptance. There is a page, Mr. Bora, letter of acceptance.
123.
Dated 4/12/2025. The petitioner was asked to deposit the security deposit amount mentioned therein. A part of an amount of rupees 70,65,000 as 15% of the EVOC was directed to be deposited in the form of an irrevocable and unconditional bank guarantee. Was it e-bank guarantee?
No. In a bank guarantee, including e-bank guarantee.
That is what I,
Though
whether the
both.
issue, both, whether you asked for e-bank guarantee.
No, Lordship, we.
No, there is a difference. That is why I am asking. E-bank guarantee, if you complete all the formalities at the bank, and it is a default of the bank, it got delayed, that is another matter. But it is a physical bank guarantee, then you have to carry it to the FCI office.
Yes, Lordship.
What mode you ask for?
Yes, Lordship, we had carried to the FCI office after.
On 15.
Physical. Okay. Bank guarantee. Full stop. The last date for submission of.
But under the terms below, they were required.
No, we'll examine.
Issuing bank was required to.
We are not reaching any view.
You have done.
With penalty. Last date of submission of the bank guarantee with penalty was 13/1/2026. Full stop. The case of the petitioner is that due to certain technical system related issues at the bank's end, the bank guarantee was not processed by the respondent number 7 bank on 13/1/2026. First off, it could finally be handed over to the petitioner on
14, Lordship, you could see page 136.
14/1/2026. And
On 14.
it could finally be issued on 14/1/2026, and the petitioner could deposit the same.
Because 14 was the holiday, 15th.
On 15/1/2026. First off, the petitioner has contended that in the bank guarantee so issued, the effective date was mentioned as 13/1/2026, and the date of start of liability was also from 13/1/2026, and the risk was also covered from 13/1/2026. First off, upon depositing the bank guarantee, the respondent FCI authorities did not enter into the contract agreement till 23/2/2026. On 23, any so-called notice?
Yes, 126.
126.
126. 23. 3.
Did not execute the contract work till 3/2/2026. On 3/2/2026, a show-cause notice was issued on the aspect of delayed deposition, delayed submission of the bank guarantee. And thereafter, by an impugn order dated 23/2024. The
Page 189 it starts, body part 192.
road transport contract has been terminated. The petitioner has been debarred from participating in any other tender inquiry with the respondent FCI for a period of 2 years. In addition, the deposited security amount, deposit amount. In addition, the security deposit amount of rupees 11,77,500 And the bank guarantee amount of rupees 70,65,000 have been forfeited. And the petitioner has been informed that the matter will be taken up for cancellation of the petitioner's MSME license.
Yes.
And Mr. Gusami has contended that the late submission of the bank beyond 31/2026 was not attributable to the petitioner. It was due to the failure on the part of the respondents of seven bank to process the bank guarantee on 13/1/2026. The bank guarantee was issued and handed over to the petition on 14/1/2026. However, in a bank guarantee, all corporates were from 13/1/2026. Upon submission of the bank guarantee on 15/1/2026, the respondent FCA authorities could have acted further for execution of the transport contract agreement on the basis of the explanation furnished by the respondent bank to them on
Which one?
3/2/2026. If the by all accounts, issue notice having regard to the case projected by the petitioner. Case projected by the petitioner, the respondent FCI authorities may proceed with the tender process initiated by the tender notice dated 5/3/2026. But the tender process initiated by the tender notice dated 5/3/2023 shall not be finalized till the returnable date. Shall not be finalized without the leave of
this. Obliged, my lord.
The proceeds which they have already forfeited, that should be.
No, I
kept-
thought,
That should be kept in a bank, my lord.
That is
so
in the
that-
bank itself.
Huh?
That is in the bank.
No, then whoever will.
amount of the amount received by the respondent FCI authorities by invoking the bank guarantee
Then the security.
shall be kept in a interest bearing during the pendency of the petition. This way or that way, that I think is receivable by the petitioner. Other things, debarment, forfeiture of the
Risk and
EMD
cost.
and termination of the contract. Those are matter of examination. But it is clear that this has been wrongly invoked.
My lord, I have to file my counter affidavit before Bihu.
The respondent shall file. The respondent FCI authorities shall file their response in the form of counter affidavit on or before
10th of April.
Okay, you want time? Okay, by 9?
Lordship, respondent FCI, Lordship.
Respondent FCI authorities.
By 10th, my lord.
10th of April. 10th of April.
Yes, now we'll file our reply and your
On the
lordship.
Mr. Bora will work in during Bihu time.
Yes. And your lordship may fix a date. So
I have fixed
Yes.
22nd April.
22nd April.
Biplab.
Obliged, my lord.
Time being matter, item number 4.
Yes, Mr. Mujumdar.
I apologize, I could not remain present in the matter of call. The last is a de-voter case, your lordship.
D-voter,
Yes, your lordship.
It can be disposed of, Ms.
Yes,
Kotogi.
yes, yes. Your lordship judgment is also there.
Heard Mr. R. Mujumdar. Learned counsel for the petitioner. It is for FT. Ms. S. Kotoki, learned standing counsel, Election Commission of India for the response number 3. Ms. Yudas, learned junior government advocate Assam for the response number 5 and 7. You are 2, 3. 2 and
8.
8. Okay, 2 and 8. On behalf of J. Pang, standing counsel, FT and NRC matters for the respondent. So the petitioner has stated that the name of the father of the petitioner appeared in the electoral roll of 1965 and 1970, published for 90 number Koliabor Legislative Assembly constituency. The subsequently, the names of the parents of the petitioner also appeared in the electoral roll of 1997 from the same constituency.
From Samuguri.
Huh? From
88 number Samuguri LLC.
From 88 number Samoguri LSC. The name of the petitioner appeared for the first time along with the name of her husband as voters from which place?
From 88 number Samuguri LLC.
As voters and residents of village.
As per page 38, Lordship, the petitioner's name appeared in the 1997 voter list also.
That is a printing mistake. 1997.
Lordship.
Okay.
Sorry, your lordship.
Page 38.
97.
You
it is
prepare
97.
synopsis wrongly.
97, your lordship. 97. I'm sorry. Your lordship. 97.
From village.
Village.
Team Larimuk.
Mua.
Post. Police station Rupoihat. Under 88 Samoguri LSC. Post of. Though the name of the petition appeared in the electoral roll of 2008 from the same Samoguri LSC. Mark Dick has been put against the name of the petitioner, and the voter mark continued to appear subsequently also in the electoral roll till 2017. Full stop. 17 and in the subsequent years also.
No, thereafter.
Thereafter?
Thereafter, no information to that.
As well as in the subsequent years, including the voter list, the subsequent years, post of para. That's 6, 7, 8. What is the police border?
It is Nagaon. SP Nagaon
8.
border.
8, huh?
8 responding.
Internal police border, Nagaon. Constituency same, Samoguri?
88 Samaguri.
Samoguri? Disposal.
Obliged.
For admission, item number 19.
Yeah, please, your lordship, the petitioner got relief.
Relief.
In item number 21 also, there is.
Miss A. Bujabura, learned counsel for the petitioner, submitted that during the pendency of the petition, the petitioner has got the relief as sought in the petition. In view of the above submission. Yes, Mr. Your name?
BC Musahari.
Mr. B.C. Musahari, learned standing counsel BTC, has also endorsed the same. Petitioner has got the relief.
Yes,
In view of the above submission made by the learned counsel for the petitioner, the petition is closed.
Item number 21 also.
21 also. So the presser has acted.
M does for respondent number 6 and
Okay, M Das. You are standing counsel?
7. PWD.
PWD লিখি দিব আর BTC.
6 and 7.
Masobless. 22.
19 and 21, right?
Item 22.
22, I need some more time there.
Mr.
R. Singh.
R. Singh, learned counsel for the petitioner.
My lord, if I may press on 1/12/2026, already instruction was given by this honorable court so that they may expedite the entire proceeding, but in past 2 days.
What is the subject matter?
Your non-payment of bill.
Oh, money. They go slow.
Lordship, my lord, that we already been communicated, my lord, one letter to them. Like,
But Mr. Revenue, please file it.
Lordship, definitely, my lord, that some documents, my lord, we are asked the deputy commissioner to supply the regarding the works.
114 PWD, Miss M. Das, learned standing counsel PWD for the respondent number 1 to 4. Miss U. Das, learned additional senior government advocate for the respondent number 5. Most of are present. Mr. J. Henrik, learned standing counsel revenue department. Has sought further 3 weeks time
Lord,
to obtain the instructions and to file counter affidavit. Full stop. The prayer made on behalf of the respondent number 6 is allowed. The respondent number 6 shall ensure that its counter affidavit is filed before the next date of listing. Post of the counter affidavit shall address on the issue of admissibility of liability as against the claim made by the petition. Place the case on
2904.
Lord.
Item number 23. Item 23.
Revision plans, malad that the GPSS state malad that writ appeal is pending malad, so
Oh,
they are enjoying.
there is no representative on behalf of the petitioner to join call. Ms. Udas, learned additional senior government advocate for the state responsible present in view of non-representation. We have the petitioner. Let the case be listed after 4 weeks. On a date to be expedite out.
Item 24.
May I plead the lordship, my lord, the petitioner executed some contractual works under the respondents and
Money after Bihu perhaps, after election perhaps. Any instruction?
My lord, I have.
BTC.
yes, my lord.
BTC.
But it has to be paid by the home department, my lord.
Receive instruction, my lord, means my colleague, but in their instruction, my lord, admission is not categorically stated, but my lord, that money asked from the my lord home and political department, 14 crore 95 lakhs have been my lord that have been asked for.
And otherwise, my lord, they may verify and make payment in a similar kind of work.
Right, but your amount is big. So let it.
In that case, my lord, it was even bigger than the petitioner, my lord, because they have executed various work, construction of barracks and.
Sir, no affidavit is forthcoming here.
Yes, on 3-4 occasions, they took time, my lord. And this is a similar kind of work, my lord, wherein this honorable court has been pleased to direct them to verify and make payment. So my prayer is also let them verify and make the payment, my lord. And because I have annexed, my lord, work order.
Madam, you file your affidavit. File your affidavit. We
Madam,
take care of it. Otherwise,
madam.
you represent whom? 1, 4, and 5.
Madam.
And Mr. BTC,
I'm for 2 and 6.
from whom it is required, Mr. Bora?
My lord, it has to come from the government, my lord.
1.
1 and 3, my lord. 1 and 3, my lord.
Who is 3?
3 is finance department, my lord.
They are not going to file any affidavit.
Yes, my lord. 1, basically 1, my lord. Home department, my lord.
Okay. Heard Mr. D.P. Bora, Learned Counsel for the petitioner, Miss Udas, Learned Petitioner, Senior Government Advocate Assam, for the respond number 1, 4, and 5, and Mr. Musahari. B.C. Musahari, Learned Standing Counsel.
2 and 6.
BTC for the respond number 2 and 6. So stop. There is no representation on behalf of the petitioner. There is again no non-representation on behalf of the petition, respond number 3. Today on call. First of all. On the previous day, Ms. Das,
My lord.
it was submitted that receive instructions partially.
My lord, partially. That was the thing, my lord, that I had stated, my lord, 14.
Ms. Das has submitted that the complete instructions
My lord.
in reference to the order dated 25 to 2026 are not yet received, has sought for further 2 weeks' time to complete the instructions, to obtain complete instruction and to file a counter affidavit. Okay, list the case on page allowed, list the case on so and so.
4th May.
For filing
4,
of
5.
counter affidavit by the respondent number 1, 2, and 4.
My lord,
Where the counter affidavit shall address on the point of admission of liability or otherwise as claim of the amount as claimed by the petitioner in the suit petition.
my lord, an observation, the last answer. On 4 occasions, they took time to file affidavit, my lord.
We are struggling with 2024 petitions claiming money.
Yes, my lord, but the petitioner has invested and he is a man, my lord.
And then when we find appropriate, we'll dispose.
Yes, my lord.
But madam, you
I'll file them. Positively, I'll try to file them.
Obliged, my lord.
Obliged.
25.
Hello, JM has filed the affidavit. It shows that we have filed it. Document before.
not possible today on a free day.
On Monday.
Monday, no.
Page 6, sir.
Monday.
The para
See
6.
today how many cases are listed.
Para
All
6.
this.
Lordship will kindly see para 6. They have stated so. Your Lordship's query is met.
If it is met. End of the matter.
That's
But Khali, I have to invest some time.
Yes. Maybe at Friday, Miller, 2 o'clock.
No, see how many matters now. These
That's all right. That's all right.
see all these people are coming up with this bulky.
My lord, we are being a decent interested person. We see our interest.
Kunde Khali ase?
24 over.
24. Tuesday.
That's
all. That is the minimum.
Maybe that day.
liberty to mention if it is listed down below.
Or 2 p.m. Or 2 p.m. Miller.
Mr. Bhotasaiji, SP Bhotasaiji, petitioner, C. Borua, Ase, D.K. Kothari, B.D. Das, senior counsel estate by Ms. R. Deka, present. Mr. Kothari has submitted that the affidavit of the respondent number 3 has already been filed and the same is on record. So, subordinate counsel for the parties have submitted that the issues concerned issues have been addressed in the affidavit of the respondent number 3. And the requisition can be taken up for final consideration. First, release the as sought for and agreed to by the learned counsel by the parties, release the case on 24. 2026. The interim order passed there shall continue till the next notice.
My lord, one concession, my lord. On Tuesday, I'm having some involvement by home.
We'll take up.
Tuesday, my lord.
No matter. Tuesday we are taking up.
Yes, on Monday or Wednesday.
Tuesday.
Tuesday, I'm having some problem. I'm having some involvement.
Give your written submission.
But it will be better, my lord, on Wednesday or Monday.
No. See, this Monday, Wednesday, and Thursday. See the position. Oh, sorry, Friday. See the position of the court. We are struggling with the motions only. Don't ask for
No,
unreasonable.
Well, at 2 p.m.
We'll take up that day. We'll take up that.
Yes. Okay.
Because 9 now.
Obliged.
Item 27.
Mister,
Yes.
name please.
Inside.
A. Hussain, petitioner present. Miss Siudas Lanet, addition senior government advocate appearing for the respondent, state respondent has sought for
My lord.
and granted
Yes, to grant.
further 3 weeks time
After-
to obtain the necessary instruction and to file the counter affidavit. Release the case on Swenson.
4th May, 405. Item 28.
Yes, Miss
He does, lordship.
P. Das, Learned Counsel for the petition is present. Yes, who is asking for time? Yes.
All the
How much
cases-
time?
My lord, in some cases, I have received the instruction and I have prepared the affidavit also, but some
Okay.
of the cases I have not received. I am yet to receive, my lord.
Okay.
So after vacation, my lord,
And where is Mr. Gogoi? Central Government Council.
he is in leg in court number,
So
number.
can we record?
My lord, yes, he is inside court.
Okay, can we record?
My lord,
Okay, for his behalf. Okay.
my lord, my lord.
আগতে repeat করি
Mal.
Further. আগতে repeat করো press along this is the case আগতে repeat করে দিব খালি date to change করে দিব
6th May, 6/5.
further to লিখে দিব
Yep.
further to লিখে দিব
6/5.
28 to 36
My lord.
The bill.
Okay, 29 to do
28 to কি হবে?
28 already done.
ও আচ্ছা। PPTD, হ্যাঁ, হ্যাঁ।
I think same
Same, madam.
same issue.
Same issue, different periods and different amounts.
A different number is different thing. There is subsidy.
Yes.
আগতে repeat করে দিব 29 over 36 same date
6/5. Item 37.
yes affidavit filed
No, my lord.
huh
Yes.
okay your name Miss Das okay you just লিখে দিব BC Musai BTC লিখে দিব it can be taken up for disposal
Yes,
release the case tomorrow please ma'am
Move. Thirty-eight.
how much time is Das
my lord.
your name
Hussain.
Hussain for is present. Miss Yudas Learned additional senior government with Assam for the state respondent has sought for and is granted. Further is granted 3 weeks time to file the counter affidavit. Reversing the claim of the petition. Release the case on so and so.
6/5. Item 39.
Same?
Same, my lord.
Same.
Item number 40.
Same?
Same, my lord.
Same.
Item 41.
Yeah, my lord, I will file.
Files tomorrow.
Oh. 42.
No affidavit.
Okay.
Same.
Item 43.
This case was fixed for consideration of interim prayer blood. Who is today
Oh, ekta-
Friday then? If least cases are there. You are ready?
Oh, my lord, and your additional advocate general P. Nayak was appeared, so.
The big Ogo has. Alia big Ogo.
B. Gogol.
Okay. Mr. Arduvil and counsel for the petitioner is present. Lodgement report.
Yes, it's there, my lord. 13.3. We said
As per order dated 13/3/2023 of the Lodgement Court. The service of notice upon the respond number 5 is complete. On the request of Ms. M. Bora.
Yes, my lord.
M. Das, standing counsel PWD, release the case on Friday. Will be risky. Eid.
Can
I don't know. I have been informed.
on Wednesday, my lord?
We can do it on Friday or Monday. Monday.
Monday I am out, my lord. On Wednesday, my
Okay,
lord.
Wednesday. Ask Mr. Nayak or Google to be here.
Deep level.
24 hours.
20.
2503.
Mr. Dubey sought leave to renew the prayer for interim leave.
Supplementary list. Item number 66.
May I please your lordship? The respondent side filed their affidavit in reply on Friday we have received it. So my lord, we are going to
Mr.
file
L.D. Roy,
detailed,
Land Counsel for the petitioner has sought for and is granted how much time?
after the question.
Okay, 3 weeks time.
Yes, sir.
To file an affidavit in reply to the affidavit in opposition filed by the respondent number
Respondent number 225.
to APGCL.
Yes, lordship.
Respondent APGCL authorities. Posted. Mr.
Lordship, my senior is
Tell your name.
R. Sahni, appearing on behalf of Dinar.
Okay. Mr. R. Sahani, Land Counsel, on behalf of Mr. D. Nath, Land Standing Counsel, APGCL, is in attendance. List the case on film.
Much obliged, lordship.
All obliged, Lordship.
Item 67.
Vehicle,
Yes, my lord.
same order.
68 same.
Same order, same date.
68 same.
That's my lord.
Miss Udas. Vehicle 66. Police
This one.
65.
68.
69.
68 to give. 68 to same. Same. Okay. 68 same. Yes.
Your lordship, the pleadings are complete. The matter can be heard anytime next week, your lordship.
Not next week. Maybe after Bihu. Bihu. Running short of time.
Otherwise, lordship, that track has already
There
been.
is an issue to be decided, your lordship. because-
The emergent issue has been
Yes, because
done.
other trucks are,
Larger issue.
because they are also facing harassment. They are not being able to transport the coal, your lordship.
Okay. Let us, I don't know, let us put it on 1st of April, we will try, otherwise it will go back
Or maybe
after you.
31st.
No, already we have fixed many matters,
Or 20.
which are more emergent nature.
Or lordship is just pass over or without any date we fix. Let me try.
Then it will not come. All dates are fixed.
First of April.
Maybe first of April.
First of April, Lordship.
We'll try. If time permits, we'll do.
Yeah.
R. Sharma, Learned Counsel for the petitioner, Mr. S.R. Burwa, Learned Counsel for the State Responsible President. It is submitted that the exchange of pleading is complete. All is the case on 1/4/2026.
God bless.
For orders, items 44 and 45.
How many baki aaye was? It is always in a nick of time.
Yes, Lordship.
Where is the first let us take review.
Yes.
Review one.
Yes.
IA with review.
Yes.
46 to other.
What are the IAs in the review petition?
1558 of 2023.
Take a silent jokes. Tell me one by one.
Yes.
Review the IAs filed in a review.
EBS.
Ah.
First one is delay condonation under section
Ah.
5.
Tell me which one.
1558
155.
2023.
That is delay.
Delay.
That is delay. Just a minute. You have not filed any objection?
No.
Mr. R.K. Vatra. Direct counsel for the applicant. And Miss P. Aforesaid. Oh, this is to be, notice is to be issued. There is one opposite party.
Branch manager. So they have not contested, my lord.
No, that is not the, what? Procedure has to be procedure. Yeah. He could have pointed out earlier. I could have issued notice then and there.
My lord, in fact, on that day, my lord, everything was, my lord,
Okay, landed counsel for the opposite party number 1.
1.
The instant interlocutory application. Under section 5 of the Limitation Act 1963. Is before seeking condonation delay of 166 days, which has occurred in filing the accompanying interlocutory application seeking setting aside of abatement. And for substitution of the legal heir stroke representatives of the deceased opposite party number 1. Ms. Aforesaid,
Yes.
you will appear for 1A to 1D?
Yes.
Okay. It will probably news. Authorized landed counsel for the response number 1A to 1D. Issue notice returnable short data behavior immediately fix data video. Fix data video.
22nd April.
As Ms. Aforesaid has appeared accepted. No formal notice. You need any copy?
No, Lord, I have
No.
already.
we have already supplied.
Steps upon the opposite party number 2 by speed post within 2 working days from today. Where is the delay condonation application in the CRP?
2023 of 2023.
then everything can be regularized. But delay that বাকিবোৰ সব সেমে হ'ব খালি তাতে লিখি দিব arising out of MSc appeal number so and so বুলি হা ইয়াতে লিখি দিব arising out of CRP number 68/2020 বা এইখিনি একেই 199 days.
Well, may I just point out, it will be arising out of the review petition which we have filed.
This IA is in CRP.
CRP.
Earlier, oh sorry, arising out of the abatement লিখি থৈছো না abatement লিখি থোৱা আছে তো abatement and substitution বাকি লিখিব নালাগে
Obliged.
date
22nd April.
22nd April. Obliged.
46.
Respondent number 1 not appeared.
Who represents respondent number 2? PN Goswami. PN Goswami. Vikas Kumar. Where is Miss I. Bautakur? Already gone, perhaps. Mr.
B. Dr.
B. Dr. Learned Counsel for the petitioner is present. The Learned Counsel for the respondent number 2, whose names are reflected in the cause list, are absent today on call. Please the case again on next to the teacher.
2703. 27th March.
Master Press.
Item 47.
You have filed one affidavit on.
And from affidavit, I have found everything you have received. Not a rupee less.
I have not received the rupees of.
Madam, you come to, you are wasting the time of the court, right? Because of the reason that you have short time, you have filed affidavit. Before filing affidavit, you took about 1 month. Now I'll come to the judgment. Page 12. Where is Mr. Goswami?
He is in another court. Another court.
Call him. This cannot go on.
Item 49.
Services complete, my lord.
Yesterday, I have seen a picture of another one serving as Deputy Commissioner Thubri.
Lordship.
As a District Commissioner Thubri, I have seen photograph in a newspaper of another person.
Lordship.
So what will happen with this name? Have you understood?
Yes, Lord.
Huh?
Lordship.
If you have not understood, consult Ms. Das.
We can include.
Shall I write it?
File
your application. Mr.
H. Tamuli.
H.
J. Tamuli.
Tamuli. Learned counsel for the petitioner has sought for listing of the case after 2 weeks in order to file appropriate pleading for implement of the new incumbent in the office of the district commissioner to brief. In the meantime, the price is out. List the case after 2 weeks on a date to be fixed by the office.
Item 50. My lord, in this case, both the respondents, my lord, have already transferred, my lord. New incumbents have joined.
Same order. Same order. RH1. Incumbents in the office of the Sadio. Iki naam asil. District commissioner going to take it on. Possible Sadio gone for Namatogo.
Item 52.
May it please your lord. My lord, very peculiar facts have emerged now, my lord. This is a petition for recalling of the order dated 21/7/2025, which your lordship has disposed of, rightly disposed of, my lord. My lord may come to page 59.
I have understood.
Yes, my lord. Now, what happened after this? After 2 or 3 months, this lady has filed a petition for enhancement of the maintenance and also for the share of the state of the late Prabodh Bhatta.
From the judgment, it appears
now, my lord,
the lady has claimed maintenance for the illegitimate.
Yes, my lord.
Minor son.
Minor son.
Of her from her so-called husband. Who died.
Learned principal judge has rightly held that he was not husband. They have lived for
No,
some
it
day.
is the case of the petitioner itself.
Yes, case of the petitioner.
The case of Swapna Roy itself, that she is not the legitimate wife of Mr. What?
Prabodh
Bhatta. So that is the projected case. That was the projected case.
Yes, that was the projected case. Yes, my lord.
And after that, maintenance was allowed to the illegitimate minor son, which was right.
My lord,
which was right.
Yes. That was the
now, whatever.
Yes.
Now you cannot say that my husband, I am the first wife, my husband allowed the proceeding to go ex parte. No, you were not in the picture then.
I was not in the picture. I came to the picture after subsequent.
Now, after that revision was filed by the husband, it was closed.
It was closed.
Due to his death.
His death.
Right?
Yes, ma'am.
Then, now the illegitimate son.
That thing has
minor son. He is having an order of the court.
Yes.
But the person from whom the money is to be realized is no longer there.
Yes.
Right?
Yes, ma'am.
Now, what is the option available for him? Against the estate?
Yes, ma'am.
Estate?
Against the.
Now, you are also
I am wife of late
being the first wife.
No,
only wife.
Only wife.
Of the husband.
Yes, ma'am.
In what capacity you are seeking review?
Now, being a wife of late Prabodh Bhatta, now my right is being affected because she is now claiming the and that subsequent proceedings she is claiming my property, my lord. So I want to recall this order. I want to challenge that earlier order passed by the learned principal.
So
wherein it has been held that
how you can enter into the shoes of your husband now in the context of 125, and whether an illegitimate minor child of a person can claim against the legitimate wife.
Let me complete it, ma'am. There in that proceeding before the principal judge, one finding is there. This child has born out of Prabodh Bhatta. Now, on that basis, he is claiming my share of right. So therein I come into the
See, on behalf of our minor son is claiming.
Yes, my lord. So I have made
You
a-
contest that.
Which one, my lord? Subsequent one.
Proceeding,
Yes,
yes.
I have obtained stay.
Huh.
But my lord, this
From whom? From whom?
from the honorable court. High Court,
Ah,
my
who
lord.
is the order?
Actually, my lord, I forgot to bring in. I have a case number. It will
Any
take
region order or without any region?
with a reason order, because 125 proceeding will, as your lordship has rightly held, it is against Prabhat Bhatta only, not with the other members or with the wife. On that ground, it has been stayed. The proceeding has been stayed. But now this is going to affect in a long run, because there is a finding of the principal judge, learned principal judge, that this child has born out of Prabhat Bhatta, which has been decided ex parte. Now I want to continue stepping into the shoes of my husband, late husband,
How
and
do
I
you
want to
connect it?
in that revision it was challenged, my lord. That judgment was challenged.
I have doubt.
Yes, my lord. It has to be examined, my lord.
Very little.
Otherwise, my lord.
Very little, no legal point.
No,
I don't
otherwise,
find any legal point. How do you examine the paternity of the child now?
that has to be.
Oh, to tell me the way out.
But that
When
cannot.
there is no way out, where is the means?
Actually, the illegitimate is decided by the civil court, not by the principal judge, my lord.
What?
Legitimate or by simply by giving a one certificate before the principal judge, yes, wherein my name is there.
How can you now step into the shoes?
Because my now right has been affected, my lord. Because that principal, the judgment was challenged by my husband.
Third, mister, I am not very happy.
We'll work it out, my lord.
I don't find any illegality. And don't find anything privacy in this
My lord is issuing notice.
notice
Yes, ma'am.
to eternity.
Wait.
Notice to eternity. B.K. Singh, learned counsel for the petition applicant, seeking
There is at page 15, my lord.
what is this petition?
It is petition under invoking inherent power, my lord, an application under section 528 of BNSS read with section 482. There is one Supreme Court judgment, my lord, it can be recalled, my lord, and I can place it.
You place it.
Syed Shah Nawaz Ali versus State of Madhya Pradesh. It has not been reported in SCC.
Which paragraph?
My lord, paragraph 12, page 3. Now, the issue which arises for our consideration is whether on that of the revisionist, the revision proceeding under section 397 read with 401 CRPC would abate. The answer to it would depend on the nature of the order under challenge in the revision. If, for example, an accused has invoked the revisional power of testing the correctness of an order rejecting his discharge application on his death, the revision proceeding would abate because the main trial would abate, and therefore ancillary proceeding emanating therefrom would automatically abate. But where the main proceeding survived despite death of the revisionist, the revision may not abate owing to the nature of the revisional proceeding. So, my lord, my humble submission is that finding of that principal judge, learned principal judge, that this son has born out of Prabodh Bhatta, my lord. There my right is affecting, my lord. So, wife of late Prabodh Bhatta wanted to step in his husband's place and want to continue that proceeding, that revision, which was closed, my lord, by this honorable court.
You satisfy me more.
My lord.
I'm not yet convinced.
When
I don't convince myself, I don't issue notice also.
Your lordship is watching notice right now.
No, I'm after looking at this order, I'm not. Again, I'd go back.
My lord, again,
Okay,
I will read para 17, my lord.
I'll again consider. I'll apply my mind. At this hour, it is not possible to apply my mind.
Yes,
Right? After going through all the proceedings in
yes,
the earlier part of the day,
yes.
list the case again on suits. Right? We'll examine. If you have a case, definitely.
I will also.
Definitely you will consider.
Yes, my lord.
No point.
Well,
Let
can it
me
be-
convince myself.
Yes, my lord, yes, my lord. Can it be on 7th of April, my lord, Tuesday, my lord?
Not Tuesday.
Because on Monday.
We'll apply our mind. No issue. In the meantime, since you have raised the issue, I'll go
Yes.
through it. 5th of April.
5th of April is Sunday, my lord.
Oh, sorry, 6th of April. 6th.
What else does it matter? Itanagar
Make a prayer then. Make a prayer for adjournment.
on 7th, my lord.
No. No. Emphatically no.
My lord, that order, my lord, where I have obtained stay, my lord.
Keep it inside. Definitely will consider. Let me think it over.
Yes.
Item 53.
Obliged, ma'am.
Your Honor, I have received instruction on behalf of respondent number 123 month, 123 month. I'm appearing for 123. I've received instruction, my lord. I may be allowed some.
You haven't received instruction.
I have received, my lord. Yesterday evening, my lord, I have received it.
What is the instruction?
That said that first two consecutive days, my lord, both parties were present. So that's why they have, my lord, my lord, but I didn't take the print. Lordship. Lordship, this it is stated that, my lord, that the petitioner filed a complaint in MSME Samadhan portal by the application number such and such against the
Same as given in the
Construct-
petition.
my lord.
AS 22, AS 20,
Gives-
number, AS 22.
I'll have to check it.
Please check.
Page 56. Page 56, no? Page 3.
You are for NHIDCL. And dispute is between whom? Your claim is against whom? Mr. Doctor?
Yes, Your Lordship, the dispute is between respondent number 4.
Who is for?
Who is,
The contractor, the subcontractor, who we had supplied them stone crusher and other units. I am a MSME unit and I had supplied the respondent number 4. It's a
Who is this for number 4?
simplex infrastructure.
Huh?
Simplex infrastructure. It is a registered unit under NHIDCL. It's a contractor.
1 minute. MSME. Will a complaint be maintainable?
My grievance is against the respondent number 1, 2, and 3. And my prayer against the reason I have made respondent number 4 a party because till now a due balance amount of almost 67 lakh is due from the respondent number 4. And so there is an interim prayer with a direction to the respondent number 5 not to release the payment in the interim.
No, you cannot approach both.
But my main
What is the status? Please inform.
my lord, it has been, my lord, closed because both the parties were absent for 2 consecutive dates. So that's why that this application has been, my lord, in absence of both the parties 2 consecutive dates. The EFC ASAP decided to close the matter in its on 17 meeting held on 21/5/2024.
the Lordship has
Then your main prayer goes.
Your Lordship, if you
Mr. Counsel,
yes,
come to page 16.
page
Page 16.
yes, Your Lordship.
Please see the first prayer.
Opportunity of hearing should be given.
No. Page 16.
The prayer.
A writ in the nature of mandamus commanding the concerned respondent number 2 to dispose of and to conclude the case,
Yes, Your Lordship.
which has already been concluded.
Your Lordship, as per the information
which I have received from the applicant, even I am not aware, this is new information to me because as per the.
That is why I am informed. Your main prayer goes. Right. Then second prayer, in read in the nature of manner was directly responsible to transfer all proceeding before this court. How can we take the role of facilitation counsel? If you are aggrieved by any order, there is provision under section 18.
18.
You go for arbitration, section 34,
Your Lordship, there is
then
a
37.
section 18 of the Act. It mandates that if Lordship would kindly.
My lord, I must, I may, my lord, that Udum case as number is not telling with his case, my lord.
Your Lordship,
It is he has mentioned in this prayer, my lord, number as AS dash.
Where from you have got this order?
we should-
Case number.
Case number, I have annexed here. Your Lordship may turn to page number 56, the application number.
56.
Page number.
Sir, why you are taking me for a ride?
My lord, this number is telling with this page, my lord, but prayer portion is not telling. My lord. This number written in page 56 is telling with my lord
Sir.
instruction.
In that page 56,
Yes, sir.
we generally believe in the council. See the first row, Uddam registration number. You have incorporated the Uddam registration number in the prayer portion. And in the top application number, this is one. You have.
Yeah.
What is the case number?
Your Lordship, I must admit one thing at the beginning. This application has been sent from a council drafted by Kolkata. I am the conducting council. So if there is a mistake, but
Why you are taking why you are wasting the time of the court?
No, Your Lordship, but this is
This is your. Where from you are saying that this number, case number?
application number.
You have taken me to page 56.
I will. Your Lordship may kindly turn to page number 61.
Please tell me.
Page number 61, the case number is written. AS 22 ASM 00246.
This is the case number.
Your Lordship, I am really sorry. I was not prepared for hearing. I thought it will be in the order
this
column.
number, yes. But application 65, my lord, what my learned friend 56, this application number is my lord.
This is Uddam registration number. This is what? Uddam registration number. This is the case number.
My lord, then I'll have to take first, my lord.
And Your Lordship, if you can see on the same page.
We are not very happy sitting at 5 o'clock
Correct, my lord.
dealing with this. Nobody is resisting.
My lord, whatever I have received over my lord.
Nobody is interested.
Mail, my lord.
And Your Lordship, we have taken the service upon respondent number 4, and it shows that the tracking report showed that notice has been served.
My lord, complaint is by the portal application, and that this is the number, this is the application in portal 56. This complaint petition has been taken into consideration by the respondent number 1 and 2, my lord. This portal application, my lord, this application has been, my lord, considered, my lord, by the one.
We don't know who is saying what.
No, my lord, this is the my instruction, my lord.
What is your instruction? Please read.
My lord. My lord, 1 to 7 is no comment. Now 8 is, my lord, the petitioner filed a complaint in MSME Samadhan portal by the application number Uddam AS-22-001453/S/00001 dated 19/11/22 against Simplex Infrastructures Limited due to non-payment of dues for supply of stone dust. In the 5th MSEPC meeting held on 29/11/22, the matter was taken for consideration. In that meeting, the petitioner MS Rhino Industries was present, whereas the respondent simplex infrastructure limited was absent. The council took serious note regarding absence of the respondent and observed that in absence of the respondent, it is difficult for the council for arranging reconciliation and to reach a decision. Hence, the council decided to call the parties in next PF meeting. However, in the 16th PF meeting held on 21/6/23, the council decided to defer the matter till its next date as both the parties have absent. Again, in the 17th MSEFC meeting held on 21/5/24, both the parties were absent. In the 2012 MSME meeting, again on 17th MSME meeting held on 21/5/24, both the parties absent. Sorry, Malad, I'm repeating. At the 12th MSME meeting, it was decided that if the petitioner and the respondent remain absent in 2 consecutive meetings, the case will be closed. Hence, the case was closed on 21/5/2024 in its 17th meeting. 21/5, Malad.
2024.
Yes, Malad. While replying to paragraph 8, Malad.
So all these facts are here in the petition.
Your lordship, if your lordship may kindly.
Then it is separation of facts.
No, your lordship, if your
No,
lordship.
all these facts are there or not?
If you have to, if your lordship can
In the
kindly keep
petition.
it tomorrow, I can appraise the court. This.
I'll also talk print and
Please provide the instruction.
Malad, I'll take the print and so
Because
on.
your lordship, as per this.
Raise the case on Wednesday. I find
Malad.
separation of fact dismiss with cost.
Next Wednesday, lordship is taken. Then Malad, I'll take again fresh step.
Because your lordship, there'll be no.
We don't know. We'll go by the document.
Yes, your lordship, definitely.
You are GR Dotto?
GR Dotto, your
You does. Begin.
Malad, deeply obliged. I'll take it.
Leave the case.
2503. Item 54.
So we have taken dusty service and affidavit of filing on private respondent.
Lordship, I am appearing for the private respondent.
You are prepared for a private respondent.
Lordship.
Okay, all are represented now. SK Usami. VM.
Look.
On behalf of Mr. B. Gogoi.
Look.
Standing out of the Health and Family Welfare Department, Finance Department.
Look.
For the respondent number 1 to 4.
Wonderful.
Our present, Mr.
B. Deca, Lordship.
B. Deca, learned counsel has submitted that he has entered appearance
Lordship.
on behalf of the respondent number 5 by filing Wakalatnama.
Yes, Lordship.
First of, let the case be listed in the admission column on so and so. The interim order, past 3 years, shall continue. Or we can let them file affidavit, interim order can be continued. List the case in the admission column on after Bihu.
2704.
The respondent number, the state respondents and the private respondent number 5 shall ensure that their counter affidavits are filed before the next date of listing.
Lordship, one submission is there. The interim order was passed on the basis of the statement made that the work order was not issued. And I have instruction that work order was issued prior to filing of.
Bring it on record.
Lordship, I will bring.
The interim order past 3 years will continue to be.
Item 47.
Yes, Mr. Goswami.
My lord, I'm very
I
sorry.
thought I could not find.
Doctor, I'm very sorry that your lordship had
Now
to
let me take to you.
Yes, my lord.
Can you broaden? First question. Can you broaden the scope
Yes. Because
of the writ jurisdiction in the contempt jurisdiction?
Because the word revised tributes.
Yes, I have calculated and I have found your claim in the writ petition was limited.
No, my lord.
No.
Prayer.
Now, please. I'll show it to you. One by one. I have invested time. I do not want to invest time on any other day. Right? Firstly, you have filed an affidavit. You have filed an affidavit now. What is the amount you have received? I have calculated in pencil. 4,77,835. I have calculated. You have not calculated, perhaps. I have
Yes.
calculated.
No, yet.
And your claim is for another 6,51,000.
Yes,
Right? Let me take to the judgment.
yes, yes. Because your
Let
lordship.
me take to the judgment.
That's good.
I do not want myself. I am sitting at 5:10. Not for wasting time on another day.
Para 7, my lord.
I am taking you to that.
Fifth line.
Where is the order?
Para 7, page 15. Page 15, para 7, fifth line.
Page 3 first. Oh, page 13.
Yes, sir.
According to the petitioner firm, it had provided consultancy service for preparation and submission of DPR in respect of 3 projects satisfactorily and had thereafter prepared the bills for payment towards consultancy services rendered by 2006-2021 invoice so and invoice so and so. Right?
Yes.
After implementation of the GST regime, the petitioner firm by including GST submitted revised invoices wide so and so for a total amount of rupees 14,77,835.
Yes.
The petitioner firm has averred that on the basis of the invoices submitted prior to the GST regime, you received 2 checks, right?
Yes.
When after repeated approaches, the respondent authorities for the year 2017 onwards for dispersal of the balance amount,
Yes.
the petitioner did not receive the same balance amount. Total amount 14,77,835. You received in part by 2 checks and balance amount. Balance amount.
In fact, my lord, there are 2 sets of bills.
No, we are into writ petition. How the writ petition was disposed of.
Yes, yes, my lord. Yes, I admit, my lord.
It is 14,77,835. You said 2 invoices. You received 2 amounts by 2 invoices. Now from your statement only.
Only one thing. My lord, this is regarding the second set of bills.
No, sir.
This is the second set of bills.
No, sir. Total
It
amount
was
is 14,77,835.
For the second set of bills.
Then I am imposing cost. I am imposing cost for taking us for a ride. Now your own affidavit. I have calculated you received 3,72,475, 6,58,857, 2,79,330, and 1,67,173. And prior to that, these are amounts you have received. And that comes to 4,77,830. So the scope of the writ petition was to the extent of 14,77,835. And you have received exactly 14,77,835. From your own statement, sir.
No, my lord.
Now, can we expand the jurisdiction of contempt jurisdiction beyond the writ petition?
Yes, my lord, that is the fact, my lord.
Well, because this matter has wasted 3-4 days.
My lord, what happened? In the contempt petition, they
But
have,
I am not hearing anymore, Mr. Gusar.
in the writ petition, they have not filed any affidavit. Therefore, there is a, my lord,
We don't know. We are, then what is the direction?
yes, direction is at page, my lord. Yes, page 14, my lord. 14, 15.
Verify the claim of the petitioner in respect of the 3 revised invoices for disbursal of the amount.
Yes, yes.
And three invoices total to 14,77,835.
Yes, but my lord, in my writ petition, the prayer was for balance amount.
Why you have consented then?
There was some,
You should have asked for review.
what happened, my lord? As because
Mr. It is too much.
the amount.
And you have said that this is disputed, this is that disputed. Okay, let us not waste half an hour time in the court. Let me find myself. Then I found myself that the case of the writ petition was confined to 3 revised invoices. An exact amount has been disbursed. That is what Mr. Vora was saying time and again. But court did not have the occasion to examine. Heard Mr.
As per the judgment, it is correct, my lord. But
Then-
in the writ petition, my lord. In the writ petition, my lord.
Mr. Please don't argue which is not legally sustainable.
In contempt.
That contempt
contempt.
jurisdiction is limited to what has been directed in the writ petition.
Only difficulty is this, my lord. They have not filed any affidavit in either in the writ petition.
Sir, you are repeating the same argument for wasting the court's time. I am not understood, Mr. Goswami, why you are repeating the same record.
My difficulties I have expressed.
You have done.
Amount, my lord.
Heard Mr. R. Goswami, learned counsel for petitioner. Post of this, Mr. S. Bora, learned counsel for the respondent, had advanced his submission on an earlier date. Post of para the writ petition. In this contempt petition is preferred, alleging non-compliance of the direction made in an order dated 17/5/2023 passed in a writ petition, WBC number 7244/2019. Post in the writ petition, the petitioner had projected that it had provided. Para the page 30, no? It had provided the parser.
In the meantime, may I pray one thing, my lord?
Para. The writ petition was disposed of, after taking note of the submissions of the learned counsel for the parties. First off, the learned counsel for the parties had advanced their submissions in the following manner. Paragraph 4, paragraph 5. Para. The relevant part, the operative part of the order dated so and so, read as under. 7. Para. In the affidavit, addition affidavit filed by the Mr. Bora had submitted that the entire amount claimed by the petitioner in the writ petition, that is 14,77,835, had already been disbursed to the petitioner. Full stop. In view of such submission advanced by Mr. Bora, Mr. Goswami, learned counsel for the petitioner, sought time to file an additional affidavit. Full stop. The additional affidavit is on record. Full stop. From the statements made in the additional affidavit, it is noticed that the petitioner had received an amounts of rupees 3,72,475 on 6/9/2024, rupees 6,58,857 on 22/03/2021, rupees 22,79,330 on 9/6/2016, and rupees 1,67,173 through net payment. Post law. The total amount so received by the petitioner is 14,77,835. Post law. In a contempt petition, the case for consideration is limited to the direction made in the writ petition. Full stop. In the writ petition, the claim of the petitioner was confined to a sum of rupees 14 lakh 77,835. And so as the petition has already been received of the rupee of the total amount of rupees 14,77,835, comma, so claimed in the petition, comma, there is no further cause of action to proceed with the contempt petition, full stop. Prayer. The petitioner in the additional affidavit has made a further claim of rupees 6,51,805, full stop, as the said claim was not within the scope and ambit of the writ petition WBC number so and so. Such a claim cannot be brought within the purview of the present contempt petition, close to. The contempt petition stands accordingly closed. I have wasted.
I'm sorry for that, but Miller, what instruction I have received. In fact, in
Sorry, Mr. Gustav. Your writ petition, it can.
the written, this amount was not there. 14 lakhs not there.
You should have filed a writ appeal or review petition, not contempt petition.